Good morning. My name is Donna Marie Collins. The date is April 8th, 2025. We're here for continuation of a hearing on an application on the South Seas Island Resort mixed-use plan development. We have heard presentations by applicants and their representatives, staff, and members of the public. Public input portion of the hearing is now closed, and we're back to the parties to address questions and issues that were raised during the public input portion and to respond to questions that I provided in writing to the parties regarding issues in particular that I'm interested in. It has been nearly 2 months since the first day of hearing in this case, and before rebuttal testimony begins, I want to remind the parties that 2 specific issues were addressed and disposed of at the start of hearing. First were motions and requests to afford party status to members of the public. The second was the significance of ongoing litigation in the context of the hearing examiner's role in with zoning requests. Motions and arguments attempting to elevate the status of certain members of the public were not accepted for several reasons. First, the administrative code identifies who parties are, and it includes only staff and the applicant. The administrative code only authorizes parties to make motions. And third, neither the land development code or the administrative code grants me the authority to extend party status beyond staff and the applicant. Several attorneys and some lay witnesses submitted copies of their letters and motions requesting party status into evidence during public input. The letters were accompanied by attachments in support of their motion for party status. Those documents and arguments are not gaining relevancy by virtue of their submission into evidence during the public testimony portion of the hearing. Secondly, ongoing court actions have no relevancy to the task before the hearing examiner. The Land Development Code outlines the scope of my authority, and it does not include consideration, interpretation, or enforcement of agreements and disputes. I realize staff and the applicant may sorely wish to address several issues and questions raised during public input, but I hope that only limited time, if any, is devoted to issues I believe have been resolved at the outset of hearing. I'd like to administer the oath to everyone who will be speaking on the record today. Please raise your right hand. Do you swear or affirm the testimony and evidence you enter into the record will be the truth?
Yes, ma'am.
Okay, take a moment, please. Silence your cell phones, tablets, so that we're not interrupted. Staff and the applicant, do we have an agreement as to who is going first today?
Yes, ma'am. Good morning, Madam Hearing Examiner. Neil Montgomery for the record. I did put some documents on your desk. I provided a copy to the county. You were faster than me, so I didn't get one additional document, which I'll hand you and Adam.
These are all applicant exhibits.
Yes.
All this,
Yes.
and then one more.
Yes, ma'am. So one of the documents that I provided you is the order from the DOA proceeding. I recognize that that is not a proceeding that directly involved you. However, there's been a lot of references to it. And it's important because there's an entire section devoted to hurricane evacuation. If you recall, Mr. Alexander read from his letter that he provided to you. And when I asked him about that and said, where's the actual study that you did? He didn't provide you with that study. He just said, I made one change to it, and here's the answer. Well, the only study that he's done was the one he provided to DOA, which he's made one adjustment to. So you don't have the benefit of that study. But what you do have is the benefit of the ALJ's analysis of both Mr. Trescott and Mr. Alexander's testimony that you'll find in that order. Plus, there's been a multitude of references to what's in that order, and rather than take someone else's word for what it says, I provided you with the document. And during Mr. Grosso's narrative, he submitted as part of his documents snippets of Anthony Rodriguez's depo and Brandon Dunn's testimony. And you'll find that on page 12 of his letter to you. I objected to providing those. They were allowed. Having been allowed, I felt it was important for you to have the depo of Mr. Rodriguez and Brandon Dunn's testimony, because they do not stand for the proposition articulated on page 12. And in fact, I'd encourage you to read Brandon's testimony. I thought I remembered it, but I read it again last night.
It sounded even better the second time.
Absolutely. I was like, go Brandon. Brandon did a superb job of talking about the 3 buckets and historical development. He goes through that at length. He was quizzed, pressured, and he remained clear, steadfast, and concise in the fact that there are 3 buckets and that the ADD doesn't set forth the historical development pattern, that what that policy in the comp plan 2324 references is 3 areas: the low-density residential, the commercial, and South Seas. And he goes at length to point out that it's a significant portion of the island, and it's its own area, and it's been treated historically as its own area. So he did a great job. I will not tell you any more about what he said, because he did it way better than I can ever do. And you have, I think I told you, you have the deposition for Mr. Rodriguez, which again, he does a better job of explaining his position than the snippet does. Both on the record and in the letter on page 13, Mr. Grosso submits, what he says here is different than what he said during his testimony. He says, SSIR unpersuasively claims that the ADD was procedurally and substantively inappropriate. And he elaborated on that a little bit at the hearing and submitted that, that we were wrong. So what I've submitted to you is you have a complaint filed by the Captiva Civic Association. And if you look at, I believe, count 1 of that complaint, did I not give you the right document? And in that document, in count 1, they allege that the administrative interpretation is illegal. That's the complaint that resulted in the settlement agreement. So there is, in essence, an order, consent order in that case. I provided you with cases, and what those cases stand for is the proposition that having taken a course of action, having declared a certain path, that the ADD is illegal, you can't now, and if it results in a judgment, you can't now, under the rule of judicial estoppel, go, hey, just kidding then, now we think it's swell. And that's where we are. They, for a long period of time, submitted that was not a valid document. And they have questioned, and even in Mr. Grosso's question, who at the county attorney's office in writing or orally told you that you can't amend that document? Who told you that that was illegal and you have to rezone your property? Well, he need only look back in history at what they allege, the CCA, to see that they've already taken that position, and having done that, they now can't change their mind. Which answers the question, do we need to amend or get rid of the ADD and give us a real zoning district? And the answer is yes, we need a real zoning district, because we can't amend the ADD. And with that, I'll turn it over to our first witness.
Where's the court order that you referenced? Because I have the 2 depositions.
I gave you the DOA order, I gave you the complaint, and I gave you the case law and judicial estoppel.
Oh, are they attached to a clip maybe, is what?
I didn't give you the court order because I thought somebody else had already given you the settlement agreement, one of the other
Okay,
witnesses.
all right.
If you need it, I will get it for you.
No, I just heard you refer to it, and I thought it was in this bundle. I'm ready.
Good morning, Alexis Crespo, Vice President of Planning with RVI Planning and Landscape Architecture. I've been accepted as an expert in the LEAD Plan, the Land Development Code, for the purposes of this case and many others in Lee County, and would like my testimony to be accepted that way again. We have prepared a rebuttal PowerPoint presentation. I'm going to give you a copy of that. I've provided that to the court reporter as well as staff. In this binder, you also have a revised master concept plan that we'll be presenting to you as part of our presentation. You have revised conditions dated April 8th to address items that we'll run through in this rebuttal, directly addressing what we heard at public comment and some of the questions you had issued. And then lastly, we do have a full response letter to the questions you issued to us on the Friday, the March 28th, within this package as well. Yes.
Which you'll be covering today, right?
Yes.
Yes, okay. Thank you, Alexis.
And so that's a lot of information. We thought the best way and hopefully the clearest way to walk you through this would be to go through our PowerPoint presentation. The experts on the team will, through that presentation, address a lot of the questions in that, but we would also like the time to just walk through those one by one to make sure that we've fully addressed them through the conditions and changes we've made since that time.
Okay, I'm just going to interrupt for a second to remind everyone that I'm going to take a break every hour and a half for the court reporter, 10 minutes, then we'll resume and we'll get right back down to business. We will take a lunch break since I think you indicated we will be going all day. And I'll continue in the same manner in the afternoon. I understand that my assistant has provided me with extra days of hearing during one of the breaks. If you can get together with staff and decide which ones of those will work for your collective parties, and then we'll have that information before the close of hearing. And that's all. Please begin.
Yes. And we agreed upon April 18th as the day to come back. And you see a lot of people in the room, and there's a lot of content we want to cover. We're not rehashing the case we made in our direct. We did, this is new information to try to be very specific to the
Very
comments
good,
raised.
because I was listening very carefully during your direct.
Yes, yes, understood. All right, so I'm just going to lay a bit of groundwork. I'll be brief this morning before I hand it over to the rest of the team. But to lay some groundwork, you very appropriately asked, the first question in your letter was, what is the delta? What is the comparison under what you can do today under your current zoning, under the future land use, underneath this administrative interpretation? What can you do today versus what you're requesting, and how does that relate to utility demand, traffic demand, intensity, compatibility, all these factors that would come into play. So I'm just going to lay some brief groundwork on that to start. This is the current zoning map the property is subject to. You'll see the majority of it is in the light purple, which is residential multifamily. The marina area in the northern portion of the site is within commercial marine zoning. That's in the brown color. And then we have a small amount of TFC2 shown in the turquoise color. And so these are our underlying zoning districts. They are supplemented by the administrative interpretation and the development standards and different allowances under that document. But these are the underlying zonings applying to the property. Of note is the commercial marina zoning district applicable to the northern marina. I'll note that the southern marina is within RM2 zoning, which does allow marinas to continue as existing only. So there are allowances for both marinas to function commercially under the provisions of the Land Development Code. And so what the code says about this zoning district is it's the principal use of land limited to waterfront dependent uses required for the support of recreational boating and fishing. This allows for local cruise ships. This allows for a variety of businesses to operate out of the marina. So that is a significant existing current entitlement that is being eliminated through the proposed MPD, and we want to compare and contrast what that can generate in terms of intensity versus our proposal, which will be to limit any public use of those marina areas and make them non-commercial. And we don't even have that use anymore. We're proposing multi-slip docking facility exclusively for residents and registered guests of the property. Also of note, the RM2 multiple family zoning districts, which does allow for a variety of conventional residential dwelling types as well as property regulations is subject to that district. So we have to marry that up with the administrative interpretation. This does very specifically go the next step of allocating units. It allocates acreage of commercial. It doesn't allocate a maximum intensity. So we have a gap in that, but a specific land area of commercial usage. For the purposes of examining the delta or difference, we proposed a relatively conservative estimate of what could be developed on those commercial lands, which are generally upfront along Captiva Drive in the southern end of the property.
And the marina.
And the marina. So that within that, we ran that as 10,000 square foot of commercial use per acre, or a total cap of 50,000 square feet, which is what you generally can fit with surface parking and all the different water management and features like that, is a general rule of thumb that we've agreed upon with the county in past cases as well. So what you'll hear from the experts is examining the impact of the current 272 dwelling units, 5 acres of commercial uses, or 50,000 square foot of commercial usage, as well as the 620 marina slips that are allocated to the property through the Manatee Protection Plan.
Can I stop you just a minute?
Yes.
The hearing examiner noted about the commercial marina, but was the commercial marina noted in the administrative interpretation, or was that a zoning done later by the board?
That was a zoning done I believe in the late 80s or early 90s by the board.
Can the property physically accommodate that many slips that you discussed? I thought during the testimony on the first day that was not achievable, and it was only useful via the slip transfer.
I will have Hans Wilson address that.
I hope you evaluated based on what can physically fit on the property and not the hypothetical of what your shorefront would permit.
Yes, and I can say from at least a planning standpoint, the 620 would not be wet slips. It would be a combination of wet slips and then buildings, dry slips within our height limitations and setback limitations of the project.
So that really wouldn't be achievable along with all the other development, isn't that right? With the golf course and the existing multifamily development.
I would say the golf course is not a required use of the property. So if you took the 120.5 acres, it
I'm just
cleared it.
hoping that this comparison is going to be based on a realistic development scenario and not an inflated based on hypothetical possibilities.
We did confer with staff on this baseline of what the ADD, and I believe they'll add that they were comfortable with how we allocated the commercial and how we allocated the marina slips. We plan on being here additional days, so if there's a need to reevaluate that, we can certainly do so. Some other pieces of the administrative amendment that I want to touch on before I turn it over to Sean, and your staff did this as part of their staff report, which is comparing and contrasting the development standards under the administrative interpretation versus what is proposed through the MPD. We are proposing to decrease the number of units on the property from the 272 to the 193. We are proposing to add the hotel uses. What you'll see in those revised conditions is a maximum of 250 slips proposed under the MPD, just acknowledging what we would feel comfortable developing on the property as wet slips and what we believe will work in that regard. And so looking at it from that perspective, in many events, we're reducing intensity, we're certainly reducing density on the site. We're also at the same time increasing our buffers, our open space, and all of the different development standards through the MPD conditions that you've seen and that are also proposed for modification. So you can see under the ADD, there's no minimum lot sizes, there's no minimum lot coverage, there's no minimum open space per tract, there's minimal setbacks from internal tract lines and roadways, as well as minimal buffering requirements, which we'll walk through in the next slide. So these are all just excerpted from the ADD. In terms of open space, again, there's no minimum open space per parcel. Through the MPD, we are proposing minimum green space of 10% per parcel, and that's in addition to memorializing the excess open space that's provided via the golf course, via the preserve areas, and other amenity within the site, well above and beyond the code minimum open space requirements. In terms of buffers, this was very permissive in terms of the natural waterway buffers, requiring no buffers in many areas where this abuts the bay and the pass, as well as no buffering between internal residential parcels. And through the proposed MPD, we are doing revetment plantings, which you asked questions about, which we'll walk you through in detail today, as well as other treatments along the Gulf of Mexico to go above and beyond the requirements in this condition. Parking. This was a significant discussion. This was talked about a lot during the public comment section. This is, in my opinion, a very, very significant change through this MPD. What is allowed today, I'm going to just go to this next slide, it's easier to digest this way. Under the current ADD, multifamily is allowed 1 space per unit and 10% guest parking, whereas the current code, which we will meet, is 2 spaces per unit and 10% guest parking. So doubling the parking currently allowed in full compliance with the code. Similarly, hotel, very permissive in the ADD. You can have 1 space per 2 units, so half a space per hotel room, plus 10% guest parking, whereas we're not proposing any reduction to that parking. We're doing 1.2 spaces per unit. That last is obscured by the screen, but the commercial area is allowed 1 space per 1,000 square foot, which is commensurate with 1 space for, well, we are proposing 1 space per 250 square foot, which is so basically 4 times the parking under our commercial scenarios per the MPD. What I would also note is the restaurant parking, that Dock Fords, which was up front, was allowed 1 space per 1,000 square feet, whereas your code requires 14 spaces per 1,000 square feet, because restaurants generate a lot of traffic and therefore need a lot of parking. So this is one area that is significantly being improved. All the code required parking is being provided on the site, and we did modify the condition about the location of parking to make sure it is sited within 500 feet of the principal use, so that we don't have a situation where all the parking is in the south or the north and people are having to get 2 miles throughout the site by foot or trolley, because we know that's not always feasible. So we've offered that up in the
Alexis,
proposed
before you
condition.
go, can I just ask for clarification? Dock Fords, which require 14 spaces per 1,000, was open to the public,
Correct.
and are we going to have any that open to the public?
No, there'll be no restaurants open to the public. The last item in the ADD is the setbacks, and it blurs the line with setbacks versus buffers. This is important as it relates to the development on Track G, the beach house restaurant that was talked about at length during public comment. It's inferred that this was developed outside the bounds of the code, or not meeting criteria of the code, or lead plan, et cetera. The beach house on Track G was issued a development order. It fully complied with the ADD in terms of its setbacks. It has a 10-foot setback from South Seas Plantation Road. And when we're reviewing the ADD and you review it as external and internal property lines, the external property lines are the perimeters, the South Captiva or Captiva Drive to the south, Redfish Pass, Gulf of Mexico, and the Bay. Areas owned by Timbers for the purposes of the ADD, since they're all in that zoning together, if you will, are treated as internal property lines. So the neighboring home to the south of that easement is an internal property line, not an external, when you're applying the ADD, if that makes sense. So there's technically no minimum setback required, as you can see, for buildings from internal property lines. You've got a 10-foot minimum building separation unless the fire department requires, or the fire code requires, additional separation. So due to the easement, yes, but even above and beyond that, the beach house exceeds the required setbacks of allowed by the ADD. So the correlation here is our setbacks in the MPD will further enhance that internal compatibility and require buildings to be even further away from what will now be uses outside the MPD boundary that remain in the ADD. This still went above and beyond the ADD requirements. The access easement itself provides the 30 feet, and then there's additional building setback off the access easement. So the total combined separation is well above and beyond. That's why staff issued the development order pursuant to the administrative amendment. Within these setbacks, there's also buffering, which applies here with a minimum 20-foot without wall or vegetation buffer. So there is the allowance within this document to have no vegetated buffer so long as the building is 20 foot away from the property line. And so and we're going to dissect the beach house later with our architect, with our landscape architect, but we're just laying groundwork here that the development, or issued by development orders, is compliant with the ADD, and it is very, very permissive when compared to the MPD setbacks that we're proposing, as well as the buffering. So those are the key points on that. So just to kind of summarize, we're increasing our external setbacks, we're increasing internal setbacks through our proposed zoning. So at this point, just another kind of foundational speaker is going to be Sean Farrell, and he's going to speak about the resort context and give you real data on how South Seas functions, both properties owned by Timbers, but also the existing units and buildings within the under the ADD, or within the South Seas Island Resort as defined in the Land Development Code. We felt, based on some of the public comment and questions, that we did not do a thorough enough job explaining to you the highly transient nature of the resort, the amount of units that are being rented and treated as hotel rooms today. And because they've owned the property for several years, fortunately pre some of the storms that have cut that down, we're able to explain to you that data in more detail. So I'll invite...
Before you go, can I ask you two questions?
Yes.
On slide 10, you have the current ADD and proposed MPD parking requirements for a hotel. There was a hotel that existed previously, had been built under the ADD and prior regulations. When that hotel is rebuilt, will it have to meet the current regulations, even though it previously existed?
Yes.
And you'll recall Mr. Witt spent extensive time talking about the LGC requirements regarding the beach house restaurant and how we didn't meet them. And I asked him if he looked at the ADD, and he said he didn't. In your professional opinion as a planner, would that be appropriate to look at the LGC and not the ADD?
No, and this is I acknowledge this is a complex project where you are looking at the ADD, where that is devoid of regulations. In some cases, the LDC does apply to development within South Seas, but where there is guidance and development standards established in the ADD, that is certainly, and in this case, the setbacks, the buffers are established in the ADD, not the code, and that would be the appropriate document to look at.
Okay, thank you.
Thank you. All right, I'll turn it over to Sean.
Here
Good
it is,
morning. Please state your name for the record.
Sean Farrell, General Manager at South Seas Resort. This morning I'd like to make myself available, and I know the question came about from the public about how many units we have in our rental program, and I kind of want to walk through that a little bit to help you understand what's in there. So we'll start with when the South Seas membership, the rental program overview, the resort amenities, and who they're available to. So the resort amenities themselves are offered to the overnight guests of the resort, the guests of the future hotel, the property owners in South Seas, both within and outside our proposed MPD, that purchase a membership or participate in our rental program, which will be called Club Captiva, which is called Club Captiva. Guests who own non-resort owned condominium units or property owners that participate in South Seas rental program. So again, if you're inside the gates and you have a unit and you'd like to use the amenities inside of there, you join our rental program and you have access via that vehicle. Or if you don't rent with another third party, you're able to buy a membership to have access to those amenities. So again, the bottom section here kind of outlines who cannot use the amenities that are offered on the property. Property owners within the gates, outside of the MPD, that purchase a membership or participate in South Seas rental program, that do not, that do not. Also guests who rent with their own condo units outside of the MPD. They do not have access to our amenities. So ultimately you have to be in our rental program or within the gates, not rent out to another third party in competition, and buy a membership to our amenities, Club Captiva.
So what's the breakdown?
I have a sheet here that'll show you what that is. Just to kind of outline some of these were the ones that struck me. Other third-party rental companies within the gates that rent: Royal Shell, VRBO, Airbnb, Sandoval Captiva Vacations, Kingfisher Vacations, Dream Vacations. These are all different rental companies within the gates. Smaller amounts of rentals, but they are within the gates and operate in there for those owners. So by the numbers, 60% of all the dwelling units within South Seas are in a rental program, meaning that whether it be with us or with other rental companies, 60% of the units within the gates are in a rental program. Of those rental transient dwelling units, only 16% of them have a 5-day or more duration limitation, meaning that there's two associations, both Land's End, which has a minimum night more than 5 nights, and beach homes that have a minimum night of 5 days or more for rentals. The other 84% of them are transient in nature and can be rented for 1 night. So it kind of lines up more with a hotel or a regular resort type of booking. When you add the timeshare units that are within the gates, 68% of the existing units in South Seas Resort are transient in nature. Again, timeshare are 1 week stays. They have a set week that they move about in. Incompatibility between tennis villas, bayside villas, and future hotel site and recreation amenities on track A1 and C. 86% of the condo units are effectively functioning as hotel rooms, as they are in a rental program nightly. So this is a document that will help kind of put it in context, and I'll run through the first line just so I make sure that I'm explaining it properly. If you go to dwelling units, and the first line is tennis villas, there's 60 units inside that of association. Out of those 60 units, 37 of those units are in our rental program at South Seas. 8 of the units are in another third party's rental program, leaving 45 or 75% of the units inside that association are in a rental program and can stay for 1 day. So obviously that proceeds right down through all of those, and you can see that this number fluctuates depending on ownership of the condos and who they rent with, or if they do rent or don't rent. So that number, it's historic. This is slow compared to historically. A lot of it has to do from post storms and people still renovating, so they pulled their units out of rental while they did renovations. You know, I don't want to quote numbers that are in the past but we're closer to 80% of the rentals being units inside the gates being in a rental program in one fashion or another. And this is basically stuff that we know that we've called around or looked up for the ones that are out of our program, but accurate in answering the question that was asked, 285 units outside of our owned assets are in our rental program as of today. Any questions about that? It's a lot of information, I'm sorry. Yes, please.
Sean,
So
before
in
you
this
leave.
scenario, 124 units are not able to use your amenities?
In this scenario, 124 units and that third party cannot use our amenities. That is accurate.
I don't know how to number those. I'll have to do it during the break, the exhibit.
We can look it up and see where we left off. I can look it up and see what number we left off.
Okay. Well, I can see the number. I don't know how to number them yet. I'm gonna have to do that during the break. What document is what number? Okay.
Neil?
Yes, no, I need to see. Sean, on slide 14, you list third-party rental companies. I know that at least one of these had representatives, several representatives, testify at these proceedings objecting to the rezoning. Maybe an obvious question, but maybe not. Are these your competitors? Are you in competition with these people?
Absolutely.
So your competitors are trying to keep you from upgrading the facilities.
In this case, yes.
Are the timeshares under your umbrella or not under your umbrella?
Some of the timeshares are underneath our umbrella. We do not manage the timeshare units. The 120 timeshare units that are within the gates are managed by Hilton Grand Vacation. Out of those, and let me slide back to that slide so we can talk numbers. Out of those units currently, Harborview Villas, which has 10 units, the Cottages at South Seas, which has 14 units, and Plantation House, that has 12 units, have in their deeds an agreement that was made with the ownership prior and have access to some of our amenities.
But the others do not.
The others do not.
How do you keep them out? I mean, they're staying.
We use wristbands, we use different things to monitor that. Our access to certain areas have RFID locks, et cetera, so we manage it via key controls and wristbands.
So that means that someone that lives in one of these other units can't go to one of your hotel restaurants and eat?
That's correct.
So how do they even verify that if they walk up or make a reservation?
Great. We're cashless, meaning that if you come to the resort and check into the resort, you can't go to the restaurant and spend. You actually have to have a room account to charge back to. So you can't put your credit card or cash and pay at that venue. You would have to have an account established, which via our rental program or our membership or those agreements that we have with the timeshare units, we set that up and you check in like a regular resort hotel and put a credit card down and get a charge card or a wristband RFID to be able to do those charges.
And that goes for the dwelling units that are not in your program, they would not have a card.
Correct, that are not in our rental program. So
So even if they own their unit and they're not renting it, and they come and use their unit,
yep,
they don't get a card from you.
they do not unless they buy a membership
Okay.
and buy amenity access.
Thank you.
Go back to that slide if you would, John. I noticed that the first line is the tennis villas. I'm assuming the tennis villas are right next to where the tennis courts were.
That is correct.
And I think I heard that they changed their name.
That is correct.
So they went from being next to tennis courts to now they're next to the water park. Is that?
Captiva Landing, correct.
So one of the things I can't tell when I look at all these names is how many of them are multifamily condos that are, we know if they're rented or not, and how many are single family. So of all the areas, of all the units that are next to high activity things, Are most of them, all of them, multifamily rentals, or are they single-family?
It's a combination. Tennis villas have 1 and 2 bedroom units. Bayside has 1, 2, and 3 bedroom units. So from a rental standpoint, to answer your question, a single family can go to a 3 bedroom unit, but 2 families can squeeze into a single family unit.
Yeah, but are any of those units actual single-family homes? I guess.
Oh, I apologize. The beach homes, beach home sites are all individual standalone homes. Beach homes do connect in places, but they are full homes. Correct.
And are they next to the high-activity areas or more Bayside?
No, they're more towards the middle of the resort. So the ones that are closer to the higher activity areas are the condos, the 1, 2 bedroom, 3 bedroom units. of that
And they're
nature.
primarily the rental ones?
Correct.
Okay. Thank you.
Okay.
Good morning. Ted Shreesh, TR Transportation Consultants. So just to cover a little bit of the transportation questions. This is the trip generation. The top table is the trip generation that was utilized in the traffic impact statements that was submitted as part of the application. The top line is for the hotel rooms, the resort hotel that was being requested, and then the multifamily units that are permitted that aren't yet developed on the property. And then the bottom table is what Alexis was referring to that was discussed with staff in terms of on the ADD, the uses that are currently permitted within the ADD based on the discussions with staff and with the applicant of what possibly could be developed based on the ITE trip generation. So what I did here was looked at ITE in terms of the marina, the multifamily, and the commercial. I just assumed some commercial development based on working with the development team, as they said, 50,000 square feet based on what Alexis had indicated. I assumed based on this, because of the location, Captiva being at the island, I assumed a 50% internal capture based on most of these uses are going to be internal, as you've heard through the testimony in this application. A lot of these trips are going to be internal. So you can see even from this a table, assuming that 50% internal capture, which I didn't assume in that top table, if you notice, that even with that internal capture, the PM peak hour trips, I know that the video is not blocking, but 385 trips is still higher than what our application is currently proposing in the 275. The daily trips, which you can't see in that table, is
Give me a second, sorry.
4,929 in that table compared to the,
What happened?
Yeah, I was trying to show the entire slide. I apologize.
I want to go back to the slide
Go from the
before.
first slide.
that number is 4,929
Go
in
to
that
the
lower
slide
row.
before. Wait, no, stay here.
You can't see the 4,000 because it's,
Yeah, it's hidden by the,
I know, but I see it's based on 620 slips, and the testimony is that only 250 can fit. So those numbers are inflated by 60%
yeah, but even
for
with,
the
you
marina.
can see the marina daily trips are only 1,400. If that number were to drop, and we can bring that number back to you. The marina is not a
Yeah, I don't
significant
want you
trip
to
generator.
assume trip generation on things that can't be built. So this is not useful to me, the way it's drafted.
It would still be higher. Table 2 would still be higher than
I
Table 1.
understand, but I would like it to be accurate.
Okay, and we can get that to you.
Can you help Louis?
What's that?
For a second?
Yeah.
I just want to clarify my testimony from earlier. Our proposal is 250 wet slips as the maximum under the MPD. It's not because that's the maximum that could possibly fit. That is because Mr. Wilson has been designing some marine improvements, and that's what they think is reasonably what they would like to construct on the site. That is not an exercise of what could fit by any means.
Okay. And you had
So
testified, though, that 620 could not fit. So I want
as
that
purely
number-
wet slips, you could absolutely construct dry slips and other means.
Okay,
But
that's fine. Let's move on.
and I also, just because of the formatting issue here, your slideshow has this slide in it. If you want to use your
So what is the
binder.
total external trips under table 2?
4,900.
4,929. Assuming that 50% internal capture. And again, the marina, we would assume the 620 would be wet and dry slips in terms of trip generation.
So table 2 represents, I'm not clear on what this is representing.
This is based on the uses that Alexa indicated earlier that could be built based on the current permitted uses under the ADD.
So why doesn't the top table include a marina or the multi-slip docking facility? And why doesn't it include the amenities like the spa and the restaurants?
Because this table up here is the new trips that we added to the roadway network. In my zoning at TIS, we looked at the trip generation of the site as it is currently being requested in terms of zoning, and this was the hotel and the multifamily. The multifamily I added to the roads because even though we're not requesting those uses, they are permitted, but they're not on the site today. So I added these trips to the table because they're not developed yet.
So does the 1,300 daily two-way trips represent the delta? Or does that represent your total external trip generation?
This is my total external trip generation that I analyzed in our current zoning TIS that was submitted as part of the application.
Yeah, and I think part of the problem is that table 2 should say the ADD, but it doesn't. It says MPD. So it might be
Yes,
creating some
that's true.
confusion.
Yeah, that should not say ADD. That's correct. And I can correct that and resubmit.
So what's the delta? Am I getting the delta from these two tables?
And we should not be looking at daily for one thing, because ITE does not report a daily trips for a resort hotel. So, and in our traffic studies that we submit and all the analysis we typically do is based on the PM peak hour. So we typically look at the PM peak hour trips. So in this case, it's 275 versus the 385. That's what I want to focus on.
Say that again?
It's the 275 trips from table 1 versus the 385 in table 2.
Wait, I gotta write it down.
So table 1 is only the MPD, table 2 is the entire resort?
It's the ADD of what could be developed
It's either case the 120 acres owned by.
on the 120 acres.
Ty, before we leave this slide, I got to clarify some things.
Please.
Under the ADD, as you calculated, was the commercial open to the public.
Yes,
And so, under the MPD, the ancillary uses, which may have been open to the public before, like restaurants, like the marina, and like some of the retail uses, aren't open to the public anymore, are they?
that's correct.
So, do you count internal capture, or you just don't look at it at all, and you just look at the main primary use? since they're accessory uses.
No, those would all be included in the resort hotel. since
What
they're
about
all-
the freestanding spa and restaurants and cafes?
But they're,
Why is that not represented on?
because they're ancillary, they're not open to the public. When you look at external trips, it's those things that are open to the public. And the spa, as Sean just testified, you can't go there unless you're already in the hotel or on the resort. So they aren't new trips on the road, they're trips internal to the project. And so I'm not going to speak for Ted, but I don't believe he would.
So the takeaway from slide 18 is that on the 120 acres that is the subject of this application, what is permissible under the ADD is weekday total PM 385. What is going to be generated by what is proposed in the request is 275.
Correct.
Did I summarize that accurately? Thank you.
And the delta is because the commercial is going.
So table 2 represents possibilities under the existing development approvals.
Yes, because the commercial is open to the public, the marina is open to the public, and we're permitted up to 272 multifamily dwelling units.
I understand now. Thank you for clarifying that.
Thank you. Was that it?
I didn't have any more questions on that slide.
Okay.
Thank you.
So the next question is, the next information I want to provide, and listening to Mr. Rourke's testimony in regards to the traffic data that we utilized in the traffic report. And I know Lee County DOT is going to offer some testimony later on, whether it will be today or in another day, in regards to the Lee County public facilities level service and concurrency report, which we rely on, as well as other consultants that do traffic studies in Lee County, in terms of the data that we use in our traffic studies that we prepare in Lee County. One of the things we did after we submitted the original zoning TIS for this report, because the data in the report was older traffic data, our firm went out and collected some new traffic data on Captiva Drive. And this shows the location that we collected that data on Captiva Drive, just over the bridge on Blind Pass, just to the north of the bridge. So just as you come off Captiva Drive heading southbound, so it would get all of the traffic coming southbound off the island and all the traffic heading northbound onto the island. So it would be the busiest spot on Captiva Drive before you leave the island or as you come onto the island. So we conducted that count in February of '25. So Lee County also conducted some updated traffic counts I believe their count was done in January. So I have that information here and I can provide that to you, but that information also showed that traffic counts really haven't increased that substantially since the data in the traffic Lee County report that we utilized, even though it was from 2010, really hasn't increased substantially since 2010 up to 2025. The data that we collected showed a volume, a peak hour, peak direction volume of 267. 267 was in the Lee County report that was in our traffic study. Our volume that we collected was 246 peak hour, peak direction vehicles. And the Lee County DOT volume that was collected was 312 in their traffic count. So not a substantial increase from the 2010 count that was in the Lee County report that we utilized. So the analysis that we conducted was entirely consistent with the administrative code for the zoning TISs The traffic data that we collected didn't result in any change in the level service analysis on Captiva Drive. So I can submit.
So this, we can rely on this information to conclude that the TIS that was submitted with the application materials remains valid.
Correct.
Yeah, Mr. Rourke alleged it was flawed, and I believe.
And I'll let Lee County speak to their reports that they produce, but we rely heavily on the information that Lee County and FDOT produce in terms of their traffic count data. They produce it, it's adopted by the Board of County Commissioners every year. It goes before the board and is adopted. So we utilize that information in our traffic studies that we produce for zonings and development orders. Our TIS, again, was reviewed extensively by the county staff prior to being found sufficient for this zoning case. So I'd like to submit this. The first is our traffic count that we conducted, and it was conducted over 2 days. So we looked at, and we took the highest volume over those 2 days. This is our traffic count that we conducted.
Thank you. Thank you.
There's some extra copies for.
Mr. Treese, before you leave this slide and go to the next slide, I have a couple questions if I could.
This is the Lee County DOT traffic count, and I think they're going to submit this later as well.
Thank you.
And one thing of note, going back to the trip generation of those uses before, there's some uses that are on the site, that were on the site previously that are no longer there. Specifically, one thing is the Captiva Cruises. Captiva Cruises operated out of South Seas for a number of years. They're no longer on the site. Based on data from their operation, they had an excess of, in sometimes over 50,000 passengers a year. They operated sunset cruises, lunchtime cruises out of the marina on South Seas. And based on discussions with their operators, over half of those passengers were non-South Seas resort guests. So they would come from off island or off the resort and were not related to the resort. They are no longer on that resort. They operate from another location now. So those trips that were previously coming from outside the resort are also no longer a part of this project. So that's even a further trip reduction that wasn't included in our trip generation. I just wanted to put that on the record as well.
Okay, before you leave this slide, let me ask you a couple questions. The hearing examiner asked to clarify the methodology used in your traffic impact study to determine external impact. I think I heard you say that you used the Lee County Administrative Code. Is that correct?
That's correct.
And another question was, does the ITE manual include data specific to destination resorts? I noticed on your slide with the trip generation, you had resort hotel noted.
Yes.
Is that an ITE designation?
Yes, and I wanted to briefly speak to that as well. ITE has several land use designations for hotels, and one of them is a resort hotel. Another one is just simply called hotel. And let me just read from the ITE land use, or the ITE trip generation report. Currently, ITE is in the 11th edition of the trip generation report, so this is from the 11th edition. The resort hotel description, and each land use code in the ITE report has a description, and I can give you these copies after I read from them. From the resort hotel land use description, The land use code is land use code 330. It gives each land use a number. It says, and I quote, "A resort hotel is similar to a hotel," which is land use code 310, "in that it provides sleeping accommodations, full-service restaurants, cocktail lounges, retail shops, and guest services. The primary difference is that a resort hotel caters to the tourist and vacation industry, often providing a wide variety of recreational facilities, programs, e.g. golf courses, tennis courts, beach access, or other amenities, rather than convention and meeting business." So this land use code primarily fits this use to a T in terms of what this land use code applies to this use. And again, prior to conducting the traffic study, we review the facility, we review the site plan, the master concept plan to determine which land use code best fits the project and which one we should utilize for our traffic study. Obviously, the county staff reviews it. If they're not in agreement of the land use code, which I've submitted many traffic studies where the county staff has come back and said that's not the appropriate land use code, we think it should be this land use code. And we've had many traffic studies where we've went back and forth with county staff on the use of land use codes from the ITE report. So obviously land use code 330 of the resort hotel is the appropriate land use code to utilize for this type of use based on the amenities that this type of facility has in terms of that. As I indicated in my primary testimony, once a guest arrives on this facility, everything is included here, that where a guest can provide all the amenities are here. They really don't need to leave the resort to have those recreational activities. The beach is there, the golf course is there, the tennis is there, the restaurants, the marina, all the recreational activities are on site for them to enjoy, rather than whereas a hotel, typically you only have maybe a restaurant, you might have a conference room, maybe a swimming pool. Everything else, though, you've got to go off-site to use.
They don't need to leave the site, but the trip generation does recognize that they're not captives. They can.
Oh, yes, yes.
Because we heard a lot of testimony about Ding Darling, the Shell Museum, yada, yada. But
Yes.
that type of trip, is that included
Yes,
in the trip generation?
yes, and those surveys that ITE does takes into account those
Okay, thank you.
trips. That's really all the testimony I have, unless you have any other questions.
No, thank you. This has been very helpful.
Thank you.
Oh, you were going to give me what you read from. Regarding the resort hotels. Thank you.
I'm back. Yeah, I know. I got a
Sean
couple
Farrell.
appearances. I'm sorry. Traffic mitigation, trolley services, golf cart parking. What we want to point out here on the property is obviously we have parking in all the buildings where all the condos, homes, et cetera, are. The additional parking is, you had made the question earlier on, where's the additional parking? And you can see throughout this map, we have additional parking down by the Clutch Golf Course, clubhouse for golf carts. There's additional parking at the main pool area that we have there. We have additional parking that will be at the beach house. We will have parking and charging available kind of mid where that one red star is. That's going to be a new spot, midway where we have a building that's being relocated from there. And of course, parking at the very front of the resort at the Captiva Landing amenity and where our plaza is up front where Starbucks is. And this is all additional parking just for golf carts. Because once you land on the property, your movement, and you made that comment earlier on, you know, people are gonna get in the car and go from one end to the other. The real objective is not that. That's why we opened up the trolley service throughout the resort, running throughout 7 a.m. to 10 o'clock at night, moving people up and down the resort, and it's for golf cart experience. That is really what the experience is. People really don't want to get in their car and go to the other place. You want to go in your bathing suit and jump in your cart. So we've added that parking throughout, and the trolley service to be able to do that, so you don't have to do that.
So the red stars represent golf cart parking only?
Correct. The red stars on here are a couple different things. You'll see trolley stops as well as parking areas.
For golf carts?
Correct.
Someone checks in, say, within the MPD.
Correct.
Do you have a golf cart rental program?
We do. We do.
And what's your ratio of golf carts to guests?
We're currently at about 150 golf carts as of today. We'll ramp up to 200 golf carts that we'll have available, and then as demand, but that will be from a ratio, what's that, 50% right now as of today? And then you have, of course,
So the other people
trolley.
would have to either take the trolley or they'll use their car?
Correct, potentially. Bikes, yes, I apologize.
Where are you storing these 200 golf carts when they're not in use?
We have a location at the front of the resort that has where our golf carts rent out of. That facility there has parking all underneath
For
it.
200 golf carts?
Correct.
Not
It's
in,
tight, but it's,
not in the MPD.
no, I apologize, yes, that's correct. It's
It's what?
outside. It's outside of the MPD, so it's outside on next to where the plaza is in the front. So if you're going down the road and you look in Starbucks in the first plaza, the next building is our building, and that's where the golf cart operation operates out of. That's where the carts are stored. That's where.
It's off resort, but that's where
Correct.
you're keeping it. You're
Correct. Ooh, we got a pointer on. It's actually right up. That's parking. It's.
Yeah.
Yep, Beach Villa is right here. That's the location of where.
across the street from the
Correct.
resort entrance.
That's correct. Exactly, directly across the street from the
Can I ask
resort.
you a question?
Yes.
Hang on, can I just write some
I'm
notes?
sorry.
Yeah, yeah.
Because I
No.
probably want to listen to
Go
what
ahead.
you're going to say.
You're on a roll, please.
And are these golf carts that you rent from this facility only available to guests and residents of South Seas, or do you cater to off-island?
We do not. We only cater to guests that are in our program that are renting through us or through Club Captiva. It's like Ted just mentioned about not having Captiva crews within the gates. It's another opportunity where we reduced and not open to the general public, and they're only contained within our resort community, meaning the resorts that we have and the units that we rent.
Okay, thank you for that clarification. Go ahead.
Okay. So when somebody checks in, do they let you know then that they want to get a golf cart, and do you deliver it to them, or do you make them have to go?
Combination. We do it online through our booking method, try to get advanced reservations so we know we prepare it. We will either valet deliver the cart to the guest, or as they check in at the desk, if there's more than more than one adult in the car, one will at the cart, we'll have it at the front desk available to them so they can take it back and start enjoying their vacation, golf cart style.
So, is the resort designed to encourage people to use the trolley and the golf carts
Absolutely.
to reduce vehicular traffic?
That is correct.
And within the proposed MPD, will you allow off-site third parties to rent golf carts to your guests?
We do not. So we do not allow third-party rental carts to come in and occupy any of our parking that we own. So if you are a resort guest, you're coming to stay with us, we confirm that via the reservation process. We'd like you to enjoy the golf cart and the trolley services within the gates, but if you choose a golf cart, you will need to rent that through us.
Are the hotel, restaurants, spa, and water park open beyond 10 p.m.?
In some cases, the restaurant inside.
So those folks wouldn't be able to get back to their room.
Yeah, unless they're in a golf cart. I mean, it's not uncommon for us. We have staff. So I have bellmen. The difference, I showed you that slide of other third-party rental companies, and it's kind of important to understand we are completely different than what they are. They rent vacation rental product just like us, so that's factual. They are in Captiva. They have a beach, but we are a resort with resort amenities with vacation rental product. So when somebody goes to the restaurant and they're harborside, and let's say they're staying at the other end of the resort, they will tell their server, a bellman will come down and loop down and grab them, or security. We have both Yukon Denali's, we have different vehicles like you would have at any normal full service resort to move people around. So it's rare, but it 100% can happen that way, and we'll give them a ride.
Thank you.
I got distracted, so sorry. I'm
Sorry.
Question. Go ahead.
Okay. Third-party shuttle service, somebody did mention in there, they use the Uber rideshare services that, once you get to the resort, I think the question was, how are you going to get back out? And that's true. It is very difficult to catch an Uber because we're not in the city. You don't have a lot of people just roaming around Captiva waiting to pick up rides and do that stuff. And we're not that type of service. We're more scheduled services. So Dolphin Transport, Island Taxi, Captiva Airport Taxi, even though they're smaller, we arrange that. That would go via either our concierge, our front desk team, or if you look at any of the social media, people post up, how'd you get there? And they'll post up any number of these different services that provide it. But it is not as simple as the mentioned in public comment to just grab an Uber when you walk outside to go there. It's not what you do anyway. You don't plan a trip with 5 people going to the airport with an Uber. You make a plan with a scheduled kind of setup. So that's how the transport, it is out there. I mentioned we do not personally run that airport shuttle, but we do coordinate with multiple different companies to do that for our guests.
Where are your employees parking on the site?
Park up in the front of the resort. Actually, currently right now, they're on the old employee housing lot that's at the very front of the resort.
That's going to be a hotel.
I think
Under
that's,
the new plan.
condo, the site.
Hotel. Where are they going to park under the new plan?
Shirley's lot.
Yeah, we have another lot that's outside of the MPD that's further up the road. So once you go past where the golf carts are, you have the post office, you have a private lot, and then all of a sudden we have another lot there. We refer to it to Shirley's lot. It used to be a,
Shirley Spirit of Thompson.
yeah, that is 100% accurate. Thank you. I heard that story. Yeah, I've heard stories about the place. So that would be the lot. That would be the lot for us to operate out of. We currently, we had bought a transit before the trolleys got back on the roam after the storm, and we have a transit that's a 15-passenger that'll be utilized to move the employees within the resort.
Testimony is the resort owns property outside the resort that is going to serve employee parking.
Yes.
That's your testimony. Okay.
There are certain employees that do come into the resort, like I am allowed to pull my car in and park by my office, and I may go up and down. I do have a cart that I use, but there are employees of ours that do park on the resort within, but the masses will be in that lot. Yes, of course, the shops up in the front of the resort, we do have parking along the backside as well, where Starbucks and the shops at South Seas, we have multiple parking along the back and underneath the building as well.
On the first day of hearing, you had testified that there was an employee shuttle. Is that going to remain available?
The shuttle to within the gates or coming out? They both will be. So just to clarify, both of them, yes. And I have a slide today for with the shuttle to help show what that is, because I know that it was asked in public comment. I don't want to breeze by it. I understand the importance of it. So I have the report from the company that we partner with to show that it's a very documented situation, that transport, and what kind of trips that reduces, and the impact for our team in savings, not using a car or mileage on their personal cars and stuff. So we do have that. which is this one. So we partner with, it's Lee County and Enterprise that has the commuter program. This is a quarterly report that they provide for us. The report is generated off of information that we collect from our teams as employees get on the shuttle. We track how many team members are on, and they calculate these reports and turn them into us. This obviously, I'm sorry, it was, if you look at it, it is back in 8/22 of 2022, so just pre the storm, where we were at that point. The employee count at that time, and this slide just shows the forecasting and the potential of the rideshare program. We had 296 employees at that time. What they identified was 133 potential employees that would be able to participate in that, because in most case scenarios, managers don't follow a set schedule, right? Expectation of a manager is you're going to work 50 hours or whatever that number is. You have to stay late if it's busy or come in early, where an hourly team member that's punching the clock can kind of fall into that. So the majority of our team is in that hourly category. And in this case, we had 133 van poolers identified, potential vans 13. And then they do the calculations to the right-hand side, speaking about parking spaces out at the resort or for employees, et cetera.
And this is an outside company that's providing?
That's
this
correct.
service?
That's correct. Well, we partner with them. We pay for it, right? So we
I
pay.
understand, but you're not having to store the vehicles at your place.
So the vans we will. So example would be if I came, we all lived in Cape Coral. So I drive, I'm the van driver. I'm paid a stipend to drive the van. I pick everybody up either at a location or I stop at multiple locations to bring people in. I bring it to work. We park that van there. I collect everybody at the end of the day and take everybody home. I hold the van at my house when I have it at home, but we do have a parking spot on property for that van to be on property during the day. But you have anywhere
13 vans.
13, yeah. But but if it's 100 employees, you don't have 100 cars coming on property. So, one of the
I
other.
wanted to clarify that you need a spot for 13 vans.
Yes, 100%. And one of the other comments was that we incentivized people to come out to the island by paying their tolls. Everybody on the island, by the way, any business out on the island pays tolls. And we actually encourage, we have incentive programs for not just this, if you're a driver of one of the vans, because we'll pay a little bit more to do that because we know it benefits everybody. We also do the same thing for carpool. We offer gas cards and things of that nature for people if they carpool with somebody else that they may work with or in another department, that offsets their expense of driving out to the island. So the report, and you'll have a copy of this, just kind of talks about some of the benefits of this van pool program that we have that comes out to the resort. This is something for the employees. Obviously, it's their marketing stuff, but it's the data behind it, the time saved for the employees, and the actual dollars, which is in my opinion, the bigger thing when you're punching the clock for an hourly position. This is the actual data that generated. So if you go to the van pools at the very top, the target for us was in that first quarter there, because we fluctuate obviously on occupancy. So as we add more hourly team members and that availability out there, first quarter we had 5 vans operating. We had 6 vans. We were targeting 5. We had 6 that operated. So you can see the gray to the green there. And then second quarter we grew it up to 10 vans that were out into the community and operating. When you go down, you can kind of see the participation by number of team members that were on those vans. So in that first quarter, we had 77 employees utilizing those vans to get into work. And then as we expanded out to 10, we had 106 employees utilizing that service to get to work. And obviously, as our occupancy or that need for more staff members, it grows out to there. Our vans go out to everywhere from Cape Coral to North Fort Myers to Lehigh to crazy. But I mean, we had vans all the way to Immokalee. At one point, I had 3 vans going to Immokalee. So it's a really great program if you are somebody who is making 15. We pay higher now due to our ownership doing that, but we at $18 an hour, and you don't have to buy a car necessarily, and you can catch a ride in. It's a pretty cool program. I know that's not for the means of this hearing, but it is about reducing number of vehicles that are coming out to the property on a daily basis. So this slide, this is a quarterly that they provide.
Sean, let me ask you a question. I think the hearings haven't asked you about the off-site shuttles, but I got a sense when you answered the question initially that you have vehicles on-site to move employees around.
That is correct. We are also, because of that location at the front of the resort where we're going to have the majority of our staff parking there on Shirley's lot, we will have a internal shuttle that'll move people around. I mean, they start at the front. We also have, obviously, where you time clock, you punch in, you get your keys. If you are a team member that operates a vehicle on the property, let's say you work in landscaping and you drive a golf cart, you and your teammate, you'll pick that up where you park your car, and that will be your transport for the day. If you're somebody that doesn't have a vehicle assigned to them for their daily duties, you'll get picked up on that either by your supervisor or by that trolley tram, it's a transit currently, to be moved throughout the resort or to rear of your home base if you're going to housekeeping, so you can do your stand-up and then be dispersed out from there via your teams.
And so the 13 vans, they aren't parked within the MPD, they're parked off-site.
They're going to be parked at Shirley's lot, correct.
Are there occasions, or have there been occasions, when there's a sudden emergency or something where you have had to transport guests or employees off-site with a shuttle?
Of course.
So that's something, if something happened and they weren't expecting it, you would make sure.
Yeah, it's the same thing with your question on after hours. The trolley service is discontinued. I have Yukon Denali's. We have different vehicles that if we needed to transport, and in this case we've had to have people go from medical, or I got a sick kid and I've got to go to CVS. I got to go in town to get something that we don't have available. So yes, of course.
You've sat through almost all the days of testimony, haven't you?
I did.
He said with enthusiasm.
I did.
Time he'll never get back. I believe that there was a lady who testified against the project because of the impact on her business. I believe she was a golf cart competitor.
She is.
So I take it she's upset that you're not going to allow her to sell golf carts within your resort.
Yes. I met with her and her husband prior to the announcement of that we were doing that and worked through that. So I think for their business model, they're frustrated because customers are going back to them, why can't I rent your cart? And, there's a learning curve with some of the things.
Okay.
Yes, is the answer.
Thank you.
Sorry. Okay. Any other?
Thank you, this was very helpful. I appreciate it.
Did you want to take a break for utilities, or you want to charge in?
How do you feel? Okay, 10 minutes. Back on the record?
Thank you, Alexis Crespo with RBI, representing the applicant. Carl Baracco is the next speaker to start addressing utilities, but based on some of the questions and comments from you this morning, we wanted to just pause and give you some testimony on how we arrived at the current entitlement scenario under the ADD, with particularly discussing the marina slips, the 620 marina slips and the 5 acres of commercial. I felt like I wasn't clear enough that the ADD, both the written document, the plan, are very explicit that there's a 5 acres pot of commercial and there's a separate pot of marina area. So those are exclusive entitlements in the ADD. The marina does not have to fit in the 5 acres. They're separate. And that's evidenced by the zoning map. Adam has the LIPA pulled up with the zoning layer to show those CM areas. My office's GIS map showed the southern marina as RM2. They are, in fact, both CM. The CM zoning totals 10 acres. So the commercial marina acreage allocated by the zoning map, by the administrative interpretation, is a total of 10 acres. And then we have our separate pot of 5 acres of commercial. So that's where we arrived at the 50,000 square foot of commercial fitting on the 5 acres and the 620 slips allowed by the manatee protection plan and allowed by the zoning and allowed by the ADD. Now,
Clearly not capable of being developed.
and this is where Mr. Hans Wilson's going to come up and speak to that because he is the preeminent expert in
He is
in
the
marina permitting. He is going to supplement this with a discussion on what can fit.
I don't know about preeminent. My name is Hans Wilson, and I've been doing permitting for 40 years, though, so I've got some scars to show for it.
Who's counting?
The 620 slip count is what was developed from the county's manatee protection plan. That's a right or a vested right that comes with the nature of the shoreline calculation in the manatee protection plan. We currently have 136 slips that are entitled via permitting. We have concept plans for an expansion for 63 additional slips, and that's all internal to the waterways that are on the site, basically expansions in the main marina. The areas that we could expand to that we have not considered at the time is the area that's out in front of the T-dock and the golf, the pool area. That whole section of Pine Island Sound, which is out open water, it's on sovereign state lands. We have, by Chapter 1820 of the Florida Administrative Code, the ability to go as much as 500 feet out into the water body. So if we wanted to apply for permits to put in additional wet slips in that location, that's something that's perfectly acceptable for us to apply for. So, but we haven't considered that because there's so much under consideration at the point in time that we are now that an expansion that we're looking at is really fairly minimal. There's also the option of dry storage. So if they decided to do an internal boat club or some sort of servicing of guests that are coming to the resort, we could put boats in dry storage as well.
Right, but my rub was when relying on the trips generated, transportation trips generated from 620 slips, that wasn't realistic for me to consider because A, you're gonna have to do dry boat storage. B, I'm assuming it's open to the public now, right? No, it's under the existing ADD. This is the assumption under the existing ADD. So the trip generation is assuming external usage of all the amenities, the commercial, the marina, and everything. So not only talking about room on the site for dry storage, but also parking, because we're having people come to South Seas now to make use of the marina. So whether they have a boat in a wet slip or a dry slip, you're gonna have to park them on the site. So I'm like saying, like, how is it realistic for me to assume everything else plus that?
Because it would be contained internally. In other words, if you were to come and want to take a boat out of the dry storage, you'd have to stay in the resort. You'd have to be a guest in the resort.
Not under the existing approval, so.
No, I'm just saying if there was an expansion.
But we're comparing what is capable versus what is proposed.
So I think Hans is only looking at it from a dock standpoint.
I acknowledge that. That's,
Yeah, it's an entitlement that just runs with the land. How we apply it, it's more likely what will happen is those slips would be transferred offsite as slip credits. That's a more practical
my concern
solution.
with it was misinterpreted. It has nothing to do with whether it's possible, can it be done, you know, whether you're entitled to it. Assuming that's true, then I'm going back to, well, this is going to take space, dry slips, parking, et cetera. Now we're starting to eat into what else could be developed on the site. So the true
Yes.
generation
Okay,
is not
let's,
accurate, that's all.
how about we try it this way? Hans, how many slips are there now? And acknowledging that you have to replace some that were damaged, so,
There's regulatory entitlements for 136 slips, wet slips.
and I think you've indicated that you would intend to add some additional slips. So how many would the next?
The next phase, we're currently working on 63.
63 new.
63 new, yes. That's internal, the internal waterways, not subject to lease with the state and not in the aquatic preserve.
So I know Hans isn't a traffic expert, but I think the difference would be the delta is that total number of slips strictly internal and that number of slips open and available to the public to lease.
Does that satisfy everybody? Does that answer?
Does that,
That's fine,
okay, we didn't get you there?
that's fine.
Okay,
Okay.
You can sit.
thank
Adam, if we can go back to the PowerPoint.
Good morning, Madam Hearing Examiner. My name is Carl Baracco, for the record, and I'm first going to go over utilities this morning. In starting, I'd like to say that my presentation this morning is going to be a little bit different than usually what I'm doing at this point in the process, because I generally am writing down questions from public comment.
They run out.
In this particular time, there were really no questions, but there was some misinformation I'd like to correct, so that's where we're going to spend the time. And both these ideas have to do with estimated utility flows, specifically estimated sanitary sewer flows. Misconception number one, in the public, someone referenced the 2015 FGUA capacity report and insinuated that maybe those flows should be used in estimating our flows. But there are some problems with that. First, that report was done for a different purpose. It was done to look at the capacity of the plant. The report itself said it was conservative, so it wouldn't be appropriate to apply those. More importantly, the old flows were based upon old fixtures, and now we're using new fixtures in our designs. So in 2017, the EPA came out with Water Efficiency Management Guide. And in 1992, they established maximum flow rates for flush volumes. That was in 1992, so everything before that was at these higher flows. For instance, pre-1994, they would have been 3.5 to 5 gallons per flush. Currently, the new technology is using 1.6 gallons per flush. So in and of itself, that's a pretty significant reduction in the way we use water. So that would show up in the difference between what water uses were used in the 2015 study and what we're estimating in the future. The bottom line, in my opinion, there is no correlation between the flows in the 2015 capacity report and future estimated flows, and the 2015 report is neither relative nor appropriate to use as a basis of estimate of sanitary flows in this case. Misconception number 2, there was significant reference to the Florida Administrative Code, excuse me, in estimating sewer flows. Specifically, referenced Chapter 62-6. But the problem with that is that section is primarily concerned with system sizing of on-site septic systems. Not really intended for central sewer systems like we have here. And there was a lot of discussion about using the number of bedrooms in each unit. The problem with that is when you have a central system, we really don't know how many bedrooms are going to be in each unit. But in the way this is used with septic systems, you definitely know that because each septic system is associated with a specific home. That's why it's much more detailed, and further, because you have one septic system with each home, there really is no cushion in that system. They have to be more conservative. So that was the misconception in using Florida Administrative Code and trying to establish flows in multifamily units, what we're doing today. Rather than that, though, FGU has criteria. And I'm going to I borrowed the slide from the original presentation just to make sure you remember that FGUA operates in 14 counties. And within Lee County, they have 3 different systems. And that's important because it establishes and supports FGUA's position on this, and this is their general notes, and they basically say that they will use the technical specifications of the county that they're operating in. In this particular case, they're in Lee County, so we are to use Lee County Utilities specifications. Before going further, I think it's important to look at Lee County Utilities history, established in 1968. Their manual does provide a source for multifamily flows, but they don't provide a source for special type developments, and I'll get into that in just a minute. So at this point, I have to make a correction, and I realized this morning when I was going through this. The attachment there is for potable water systems. I intended that to be sanitary systems, so if I could give you that.
Okay.
So what I just handed you is section 3 from the Lee County Utilities System designs, and it establishes the multifamily residence at 160 gallons per day per residence. That is what we used in calculating our sanitary flows for multifamily. So this is also from Lee County Utilities, talking about, lost my place there. Yeah, the special types of developments from Lee County, and then they do reference Florida Administrative Code. So in Lee County Utilities, when you have a single family or multifamily, they have specific uses. When there's special uses like this, a resort hotel, they do reference you back to the Florida Administrative Code. And that puts, the Florida Administrative Code puts the flows for resort hotels at 200 gallons per day. Again, that's what we used in estimating our sanitary flows for this application. I hope that clears up the basis that was used for estimating sanitary flows in requesting the letter of availability from FGUA. Estimated sanitary flows and potable water demands were estimated based upon Lee County Utilities design guidelines and are the basis for each of the letter of availability, which were both accepted by IWA and FGUA. Again, IWA and FGUA did review the future demands and flows associated with the zonings, and each has acknowledged that they have capacity for this application. If you have any questions, I'd be happy to answer them at this time.
I don't have questions, thank you.
I do, though. Mr. Baracco, how long have you been an engineer registered in the state of Florida? Not to age you, but there's a reason.
Approximately as much as Mr. Wilson, about 40 years.
And during that time, about how many times, this is an approximate, have you or your company submitted for letters of availability?
I would say hundreds of times.
And how many times have you done an analysis to determine water and sewer demand?
Hundreds of times.
And the 2015 report that was provided by Mr. Evans as an exhibit, he offered opinions on both that and the Florida Administrative Code. But he doesn't have an engineering degree, and other than he has done reviews and worked for the city of Sanibel, he didn't identify any expertise that he had relative to this. So because you've done hundreds of submittals, have you become intimately and abundantly aware of what the rules are and what can affect those calculations?
Yes, I have, and to elaborate on that, if I tried to do an estimate based upon the Florida Administrative Code for single-family homes or multifamily homes, I don't think it would all be considered by Lee County Utilities or FGUA for that matter.
Okay, thank you.
Thank you.
Thank you.
Thank you, Madam Examiner. My name is Noah Valenstein. I think you've got a copy of my resume already in the book provided to you by Alexis. Just as background, I had the privilege of serving as Secretary for the Department of Environmental Protection, both for Governors DeSantis and Governor Scott, and also served as the Chief Resiliency Officer while I was Secretary of DEP for the state of Florida for Governor DeSantis. I, prior to that, have served in other environmental roles, such as head of a water management district in Florida and advisor to governor. And I just wanted to follow up on, Carl, if you got the clicker.
So what is
got
your
it.
background? Is he a planner, an engineer? What is
I'm
he
an
exactly?
I'm an attorney and then formal public official.
Okay, thank you.
And so just following,
I'm sorry, I haven't had you testify before me,
Yeah.
and I was trying to put you into a description, that's all.
Maybe describe your consulting firm as well.
sure. And so I currently, after stepping down from public service, have a consulting firm, Brightwater Strategies Group. And so we work with high-end development, agriculture, environmental investment funds, and other advising on policy, external affairs, and working with development. And then also serve on a number of environmental boards and education institutes in Florida.
Okay, you may proceed.
Okay, thank you. So just to follow up on Mr. Bracco's comments, looking at the wastewater treatment plant, during my time as Secretary of DEP, the Florida Governmental Utility Authority had a very good reputation for capacity to maintain its plants and work throughout Florida. I wanted to highlight that it was recently provided with a $7 million award. So despite having the capacity to maintain the plant and the plant, at least on my tour, appearing to be in very good working order, they're looking forward prospectively and work to receive a grant from the state of Florida to make improvements to that. The state's been very focused on reducing septic and improving wastewater facilities throughout Florida. And I'm happy to provide just the governor's announcement of that grant and then DEP information on that grant should you wish it.
So this specific grant is targeted for the South Seas Island Resort Facility?
This is targeted as a grant to FGUA to make improvements to that wastewater facility so that it could even further reduce nutrients from that. So as I was mentioning, DEP has been very interested in the legislature has been very interested in reducing nutrients from wastewater facilities, specifically septic, but also being able to increase the capacity of wastewater facilities so that they could take on septic, right? So that folks could, instead of having a septic tank, connect to a wastewater treatment plant. And so in the fiscal year 2023, 2024, I apologize for that typo, the state provided a Clushatchee watershed grant. This was the first year that this grant was available, and one of 6 awards went to FGOA, $7 million. And FGOA committed to proceed with the most cost-effective approach to removing nutrients from the wastewater treatment facility, basically improving the quality of the facility, as well as including an additional ejection well to give them even more flexibility about managing that facility. In general, I would mention that Florida Department of Environmental Protection under Chapter 403 of Florida statutes has the regulatory authority and supervision over wastewater treatment plants. They've got strong oversight, wonderful staff, work for compliance, but also assistance to make sure the wastewater treatment plants are operating well. I mentioned that as response to a public comment referring to a warning letter from DEP to FGOA on February 5th of 2025. At least our review of that warning letter did not see anything that would conflict with the utility statement of availability. But what we did was sort of go through and did a public review of the DEP's compliance assistance and supervision for wastewater treatment plants on the island, right? To sort of look at their engagement there. That's all public record. They have a wonderful online permitting system where you can go in and look at the wastewater facilities. So the 2 facilities we had were FGOA facility on Captiva Island and then the Sanibel Donex facility. And in doing that and looking sort of over the past couple of years from 2023 to 2025, saw more than 30 reports of various spills and leaks and sanitary sewer overflows. It appeared about 24 were occurring at the Donex wastewater treatment plant and about 6 at FGOA's SSIR wastewater treatment plant. I'll mention and can provide just a sample of some of those letters, but they sort of matched up in that there is a February 3rd, 2025 compliance assistance letter for Donex that matches up with the similar time frame for the compliance letter that was mentioned in previous testimony. And so it looked at storm events. There appeared to be similar compliance assistance offers to both wastewater treatment plants. Sort of our takeaway from it was that DEP is engaged. They're providing oversight, compliance assistance, and then providing grant funds to improve plants to have sort of a continuous improvement of operations. And everything we saw was that FGOA is a very good operator and now well situated with their own funds for maintenance, but also state assistance. And so with that, Madam Hearing Examiner, I would offer the grant award from the governor's website, the DEP informational on the grant for FGOA, and then a sampling of warning letters just looking over the last couple of years from the island, a February 3rd to Donex, a July 25th to Donex, a November 27th letter for the same plant, and then a February 23rd for the same plant.
All right, so these go together.
Yeah, that goes together.
Let me just.
This is the second, so that shows the location and then the list. This is all taken from the department website. And then here's the sample of just 4 letters.
All right, those have all been marked as exhibits.
Thank you. Mr. Valentine, I'm going to show you a document. Do you recognize that document?
It is FGUA Notice of Permit Issuance.
And can you tell me who's the secretary? Note up in the upper right-hand corner.
That would be myself. That was back March 2021.
And can I ask you to flip to page 8 of that permit?
You have to help me with the page number. Oh, there we go.
And page 9, can you take a look at that? So does that purport to be the operational requirements imposed by the department and yourself on the FGUA permit?
Correct.
And do some of those conditions purport to have water quality requirements and restrictions?
Correct.
And is DEP responsible for ensuring that those water quality standards are met by FGUA?
Yes.
So, thank you. I'm going to introduce that into evidence.
Okay.
Thank you.
Thank you. No other questions? Thank you. Oh, sorry.
This is the permit issued to the FGUA facility on the MPD?
Yes, it's a March 2021 permit issued by DEP to FGUA. We'll come back to that later. There'll be more testimony on that to help answer some of your questions.
Is that, can you turn your phone off? Because it keeps going off and it's distracting me.
I'm sorry, I didn't think it was mine, but it could be. Might be my watch.
Every time it vibrates, I feel it on this.
I think it's my watch vibrating.
Oh, okay.
We're gonna put it in we're gonna hide it.
Thank you. I'm trying very hard to concentrate.
I'm sorry.
Yes.
Good morning, Kathy Olson for the record. Do you want to move forward? Or do you want me to? Okay. I thought you were in control. All right, I'm going to go over some comments based on testimony we heard during the public portion. As a reminder, all of the proposed development will be in already disturbed areas of the property. No intact native communities will be disturbed by this project.
So let me stop you right there. There were numerous people who said, we're going to impact, animals and vegetation, and we're going to be creating additional impacts. So based on what you just said, all those statements are not true.
All of the development is going to be within areas that have previously been disturbed, correct?
Okay.
The existing mangrove preserve, which is roughly 40 acres, will be remained intact. The only thing that will happen is some trimming along the road right-of-way around buildings, etc. No large-scale destruction of the mangroves, other than perhaps a boardwalk in the future. All of this mangrove is providing habitat for listed species, such as wading birds, as well as migratory songbirds that are here. Additionally, wildlife crossing signs and educational signs will be installed along the road to educate the public about their driving, how their driving impacts wildlife, as well as fast facts about the wildlife that are on Sanibel and Captiva. And further, all of the South Seas golf cart rentals have a geofence which prevents them from going onto sensitive areas such as the beach. All of these things, with an asterisk, exceed code requirements.
And are these going to be conditions of approval?
These are things that we're committing to.
Okay.
They are in the conditions. They are in the conditions.
The
Proposed conditions you haven't seen yet.
Okay, just give me a minute so I can look at this. Okay, so explain this fence, this geofence, what is that?
It's a sensor on the golf cart that makes it so that you can't travel through certain areas. So you can't drive onto the beach, you can't drive probably off the property, is that correct? It's kind of like,
GPS.
yeah, it's
like
a
golf
GPS
carts. You
thing.
can't take, or not golf carts, shopping carts, you can't.
Right, that's a good analogy.
If you need more on that, Sean can explain it.
No, that's all right, I understand. So what, it disengages the golf cart so it can't
Correct, so you
proceed
can't
into
go.
an area that's,
For all intents and purposes, yeah. All right, sea turtles. Tinted turtle glass will be installed on all new construction post-MPD, including windows that are not directly visible from the beach. That exceeds code requirements. Usually it's just, the code requires windows that are facing the beach, and the applicant is going beyond that. Additionally, when people check in, they are reminded to close the curtains. That gives an extra buffer for light from leaving the rooms. All exterior lights on the new construction will be sea turtle compliant. So not just the ones facing the beach, but throughout the development. Additionally, South Seas staff remove umbrellas, beach chairs, leftover coolers, et cetera, during sea turtle nesting season.
you mean at night?
Correct. Before the nesting sea turtles come ashore or the hatchlings go to sea. Additional dune plantings will help with any light spill onto the beach, and all of the parking areas will be enclosed with buffers or buildings to limit light pollution onto the beach. The individual turtle nests are monitored and marked by Sanibel Captiva Conservation Foundation employees, and the marking helps with sea turtle nest disturbance, preventing.
Regarding the new construction lighting will be sea turtle compliant, are there existing buildings within the MPD's boundaries that are beachfront then that will have lighting that's not compliant?
Not beachfront, no. I believe the only one is the restaurant, the small restaurant.
It has, yeah.
It does have turtle compliant, okay.
Okay, so there's gonna be sea turtle compliant lighting throughout the resort?
I believe that's the case, yes.
In beachfront areas, obviously, it's,
Right, but there's a proposed condition to that effect.
okay, thank you for the clarification.
Non-beachfront too.
Shorebird conservation, the tinted turtle glass will be installed where we said they would be installed previously. Exterior lights also will not, lighting will not reach the beach. Dogs are not allowed on the beach per the LDC. And we will go further with putting no unleashed dogs on the beach signs. And again, employees from Sanibel Captiva Conservation Foundation mark shorebird nests, if there are any. As far as migratory birds go, the LDC does not cover migratory birds, but this development will have exterior lights that are shielded. That will prevent the nighttime migratory birds from becoming trapped in the light and perishing. Additionally, turtle glass also will prevent light pollution that will help with that as well. And again, just the sea turtle lights will help prevent, and the curtains will prevent light from going out of the individual rooms. All these things combined make it so that migratory birds can safely pass through the area at night. And again, none of the migratory bird condition, or none of these things that are required by the code. Everything in here is voluntary. And that's it.
Thank you.
Okay, wait, before you leave.
Sorry, Neil.
I just want to, on slide 46, third bullet, it says, exterior lights on all new construction DOs post-MPD will be sea turtle compliant. I just want to kind of go back to that. So under the county's LDC, every building would not have to have lights.
correct.
So anything that's not on the beach under the LDC wouldn't have to have,
That's correct.
and we're going to be providing that.
That's correct.
So that,
Going above the code. correct.
okay. Thank you.
I was wondering if I was going to see you during this hearing.
Here. And here is a copy of my resume. And I also provided her one of my business cards.
Mr. Brown, I know you provided your resume, but if you could, just for the record, give a highlight of your expertise and experience.
I've been practicing as a professional geologist in the state of Florida for over 38 years. My total experience now is approaching 42 years, 42 and a half years in Southwest Florida. So I have a lot of experience. Through that entire time frame, I've been involved in both the collection of water quality samples, laboratory analysis of water quality samples, the review of water quality, and then using that for data, for permit applications and engagements with regulatory agencies. So I have a long permitting history as well. I've permitted, I do water use permitting, ERP permitting, and a lot of different aspects, predominantly regarding the water management districts, but we also do, my company performs DEP permitting, as well as Army Corps permitting. So we have a lot of permitting in my background and a lot of water quality work.
Thank you.
All right. Well, again, my name is David Brown. I'm a certified professional geologist in the state of Florida, and I'm the national practice lead for my company, Respect Company LLC. And I'm the national practice lead in hydrogeology. And this morning I'm going to go over the characterization of ground and surface water resources and hopefully provide some clarification on some of the things that were testified to earlier. First off, at the very beginning of this, I'm going to start with the lead plan, but the terms reclaim water and reuse water are often used interchangeably. All right, so typically the more correct term is reclaim water, because reuse, if I irrigated a farm field and it ran down to the bottom of the field and there was a lake and I picked it up and brought it back up, that would be reuse, and it had nothing to do with reclaim. But those terms are used interchangeably, and in fact, in the LEED plan, they use the term reuse. So please, and you'll see some of the inconsistencies with those definitions as I go through some of the my slides. So again, reuse water, okay, it's defined by the LEED plan, is treated wastewater, which, as a commodity, is sold to various users for agricultural irrigation, grounds management, institutional lawns, golf courses, like in this case, or industrial uses. Sometimes it's used purely for industrial processes. Looking at the LEED plan under standard 4.1.3 under reuse, any development that requires a development order on a property that is adjacent to a public reuse infrastructure, i.e. pipelines, a pipeline network, with sufficient capacity must connect to the reuse system for irrigation needs. Policy 13.8.9 for private recreational facilities, i.e. golf courses or similar, located outside of a depicted well field protection zone, which we don't have any well field protection zones here. Reuse water, where available, will be utilized for irrigation, and that's also codified in ordinance. And policy 61.1.6, when and where available, reuse water should be the first option in meeting irrigation needs of a development. Where reuse water is not available, surface water or other low-quality groundwater will be used for irrigation. That little image is going to mess with all the slides, most likely. But anyway, it's the number one choice, if available. So now kind of backing out and starting with Chapter 373 Florida statutes regarding water resources. 373.250, reuse of reclaimed water. There you see that discontinuity in terms. The encouragement and promotion of water conservation and reuse of reclaimed water as defined by the department, and that's the Department of Environmental Protection, used in this chapter are state objectives and considered to be in the public interest. The legislature finds that the use of reclaimed water provided by domestic wastewater treatment plants permitted and operated under a reuse program approved by the Florida Department of Environmental Protection is environmentally acceptable and not a threat to public health and safety. Now I'm kind of zooming in to more specific.
Where was that from? That's
Where-
from the statute?
That's from the statute. Yep, Chapter 373. Now looking at the water use permit applicant's handbook, South Seas has a water use permit that was issued by the South Florida Water Management District. So all of us that do water use permitting, you have to go by the applicant's handbook for water use permit applications. This one, the one that I'm pulling from, is from June 13, 2022. And under 2.2.4, reclaimed water reuse criteria, again, you see that, that terminology. The encouragement and promotion of water conservation and the use of reclaimed water are state objectives and considered to be in the public interest. So they're kind of re-echoing Chapter 373 right there. Environmental feasibility, reclaimed water reuse is considered environmentally feasible if the department has permitted the reuse facility that will provide the reclaimed water supply. Again, kind of echoing what was in Chapter 373. Oh, I'm sorry. Sorry. Reclaimed water use is considered technically feasible if the reclaimed water is available at the site at the proposed use to meet all or part of the applicant's needs as defined by their application. So what does it mean by that? The Water Management District will only issue a certain amount of water for a particular use. And they analyze that. And so they're not going to give you any more if you're going to use reuse water or reclaimed water than they would if you used 100% groundwater or surface water. So it's all based on that reasonable and beneficial need. So South Seas Resort, their specific water use permit. You can see the permit number that I have there, 36-00109W, and the expiration date is May 19 of 2036. It's a 20-year permit. They obviously can renew it prior to that, up to 1 year before that, but the permit is good till 2036. And then South Florida Water Management District has a staff report which is part of the permit, okay? And it says, direct quote, irrigation for the project area supplied by 3 wells that are finished into the mid-Hawthorne aquifer. That's the intermediate aquifer system. Reclaimed water is also used for irrigation. And they also say the reclaimed water supply is delivered to an elevated storage tank from the South Seas wastewater treatment plant. South Seas Resort routes the water from the tank into their main irrigation supply line based on their irrigation schedule, and pumps groundwater from one of their wells, well MH, to the tank, depending on the operating tank level of 18 feet. At 18 feet, the well pump is turned off automatically as a float switch, so the storage of the tank is approximately half full and always able to receive reclaimed water. So this tank comes out of the wastewater plant, it goes to this tank, and this tank is also supplied with a groundwater well. And so the district wants you to maximize the use of reclaimed water, but if there's a shortfall or they needed a certain schedule, they have the ability to add groundwater into that tank and mix it with the reclaimed water before it even gets used for irrigation. You were provided earlier a copy of the wastewater permit for South Seas. First off, this permit's only issued every 5 years. Has to go through the conditions of issuance every 5 years to get that plant, to recertify that plant. It's an existing 264,000 1,000 gallon per day or 0.264 million gallon per day average flow. And the way the terminology is R001 is a reuse system that consists of spray irrigation. And if you look at, I can do this. How do you hit the little pointer on this? Oh, that guy. Okay. Down here, this permit, so we had the water use permit recognizes the use of both groundwater and reuse water or reclaimed water. This permit also recognizes that there's the ability for the irrigation supply to be supplemented by the use of groundwater. So both of these permits are kind of mirror images of one another, and they basically are coordinated together. So let's talk a little bit about the reuse water itself. And this is directly out of the permit that you were provided earlier. DEP wastewater permit requires that FGUA perform extensive testing of the reclaimed water prior to its use for irrigation, including monthly testing of total phosphorus and total nitrogen. You can see some of the other criteria that they go through. This water is chlorinated before it gets used, but they're looking at flows, turbidity, pH, bacteria, but specifically in regards to nutrients, they're looking at total phosphorus and total nitrogen, and those are grab samples, and those are required to be looked at on a very frequent basis. So I made a little graphic to try to explain, so we know kind of what the water quality is being monitored.
How frequently is it tested?
Monthly, and it's in the report, in the permit. So I testified earlier that both the DEP permit and the water management permit recognize that groundwater can be used to supplement the reclaimed water. And so what I did is I went into the DEP Oculus, that's their e-permitting portal that you can look in, public portal that you can go into. I also looked into the South Florida Water Management District permitting portal and said, okay, how often are they adding groundwater to that tank on a monthly basis? And so I looked at 18 months of data. Okay, and on average, about 20% of the water in that tank is groundwater. Some months it's less. One month it was over 90%. So it just depends on the demand and timing. But that represents another form of treatment to this water of sorts, because we're adding groundwater and diluting it at that stage in the tank before it even gets used for irrigation. And again, on average, about 20%. So then what about when it gets used for irrigation? Okay. First off, as I testified earlier, there's 3 groundwater wells. There's 3 monitor wells that are monitoring the use of this water at the golf course. And I'm sorry, I probably just confused you. There's 3 supply wells and there's 3 monitor wells. They're 2 different things.
The supply wells is what's drawing from the mid-Hawthorne.
Correct. And the monitor wells are only 15 foot deep, and they're monitoring the superficial aquifer system. And those monitor wells, there's 3 monitor wells, and what they represent is a background sample, and that is this well that is right here. It's SSP3 right here. Notice it's nowhere near the irrigation area of the golf course. It's outside the influence completely of the wastewater treatment plant, so that's the background water quality well. And they also have what's called an intermediate well that is within the area where the reclaimed water is being used. And more importantly, they have a compliance monitor well that is used that's outside of the irrigated area and down gradient to look at, is there any influence from the use of reclaimed water at that facility on that area. So there's 3 monitor wells. These are the parameters that those are looked at quarterly in the monitor wells. So we're looking at water level, but now we're not looking at, even though it says total in the permit, it's really nitrate that they're looking at, so it's one of the constituents of total nitrogen. Total dissolved solids, arsenic, chloride, cadmium, chromium, lead, coliform, pH, sulfate, turbidity, specific conductance, temperature, and DO or dissolved oxygen. That's done every quarter.
Pursuant to the permit.
Correct. Oh, jumped. So what does that data look like? Okay. So again, as I just stated, for land application of reclaimed water, DEP requires the plant operators to monitor groundwater quality quarterly. And again, I'm comparing in this plot, and take some time to look at it, but the orange line is the compliance well. It's unfortunate that this image is covering that, but the blue is the background well. So remember, the background is having zero influence from the use of reclaimed water, and the compliance monitor well is looking at it outside the area where it actually is used. First off, the standard is 10 milligrams per liter. And you can see we've never violated the standard. But the curious thing about this data, if you look at it, we have spikes in the blue in the background well, one that was right here, and it's unfortunate that happened in 2024. And then you also have kind of this little peak right here. It's a single data point that happened in 2018. So we have some ups and downs in this, but they almost correspond together, that when background conditions are elevated, that we see also a corresponding elevation in the compliance well. So it may be coincidental or it may be related, but it is curious that they occur at the same time. But if you look at it overall, these values are very low for nitrate. Overall, we're below 3 milligrams per liter is a dashed line. Generally, on average, we are. But really, most of the data is below 2 milligram per liter. You're almost approaching AWT water quality at this stage. So looking at this compliance well,
AWT.
advanced wastewater treatment, there was some and AWT is a lot of wastewater plants are undergoing AWT transformations where they add additional treatment train to the system to further reduce nutrients. So that's what AWT is. So we're already very close to reaching, if not really reaching, AWT standards, looking at our compliance well. Staying on water quality, there was some previous testimony regarding tidal pumping. It's kind of a cool term, okay, interesting term, okay, but as with all things, the devil's in the details. And the Gulf of Mexico, to anyone that fishes, experiences 4 tides per day, 2 high tides and 2 low tides, but it's what's called semi-diurnal. It doesn't all happen in one day. And what I have up here at the top, this is right at Captiva, okay, and I took this is recent data, the tides. And if you look at this, I won't go too deep into it. I'm not an oceanographer, but I can look at tide charts. Here's a high tide, then we have a low tide, then we have another high tide, a lot higher than before, then we have a low, and then we have this kind of low high tide like we had before, and then a low low, then we have another high tide. So that's a unique signature to the Gulf of Mexico. Why? Because it's a constrained water body. We've got Florida on one side, Texas, Louisiana, and Alabama, and Mexico. So it's not like an open ocean of water. And so as it tries to match, you have the tidal range, and this is for Daytona Beach for the exact same time frame and the same scale. So we have about 3 foot of fluctuation here, but it's this kind of odd fluctuation of high, low, sort of high, sort of low, so it's very different. This is Daytona Beach, and you can see, and it's the same vertical scale, that we have almost 6 foot of oscillation or amplitude that occurs, and we don't have these little kind of mini highs and mini lows. So what does that all mean? For tidal pumping to occur, groundwater levels need to be higher than the tide, and as the tide fluctuates and it gets low, theoretically that increases the gradient, so water would start to move towards the tidal region. But in the Gulf of Mexico, then we have this kind of little high and little low, so it kind of confounds that process. So tidal pumping is something that can occur, absolutely, but it occurs in areas where you have large swings in tidal fluctuation. You've got to have permeable sediments as well. I've done quite a bit of work on, it happened to be, nothing to do with reclaimed water, a contamination project on coastal Manatee County. Did a lot of monitoring. We did not see any evidence of tidal pumping, okay, as we went through. In addition, conversations with some of the operators at the golf course, they don't see their stormwater ponds fluctuating up and down, showing a strong relationship to tidal influences. So I don't believe that tidal pumping is appropriate in this area. And if it has any effect, it's really very, very small as compared to areas like the east coast of Florida. So again, I've talked a lot about the FDEP and also the wastewater treatment plant. And this is what NOAA said. I mean, they basically got a $7 million award from DEP. And again, the scope of work for that is to enhance the treatment capabilities. This is right out of the scope of work for the existing South Seas Plantation wastewater treatment facility, reduce nutrient loading, and provide additional effluent disposal capabilities. And what that means is they will also allow them to have additional deep well injection for disposal. So they'll be, they already have a well where they can dispose of the reclaimed water, but they'll have redundancy in that as part of this DEP grant. So it doesn't have to go to the golf course. Okay, we saw that permittees and people through the LEED plan that you're obviously very strongly encouraged to use reclaimed water, but it doesn't have to go there. If there was an issue or some problem, the disposal wells could be used. Now, staying on this topic of water quality, I looked at this report. Anybody can find it online, and it was a report done by a firm that I know, consulting firm ESA. I've worked with them, and it was a study for the Captiva Community Panel Wastewater Committee. And it was looking at septic tanks, but as part of that study, they did a nutrient loading model for all of Captiva. And I know other nutrient models have been performed. They're referenced in this report. But looking at that nutrient model that ESA put together, right out of the report, based on ESA's work, this is a direct quote, South Seas Island Resort's use of wastewater effluent for golf course and other irrigation needs is a fairly minor source, approximately 6% of island-wide nitrogen loads from stormwater runoff. So I read that and I went, hold on a minute, this is a zero discharge facility. In other words, it doesn't discharge stormwater through an outfall. There's only two ways for stormwater or runoff to get out of. It goes to the stormwater ponds, runoff. It can evaporate or infiltrate. It's the only two ways. And so we're monitoring that infiltration by the monitoring wells as part of the wastewater permit. So I called the author. I know him. I've worked with this individual, this PhD, for many years. I worked with him at the Water Management District. And I said, hey, did you take into consideration that South Seas was a zero discharge stormwater facility? No, they did not when they put this report together. So then I said, did you further understand or know that they augment the reclaimed water with groundwater? No. So as part of the study, they looked at septic tanks and other things. They weren't looking deep into the permit like I've done. But obviously, based on those two comments from one of the authors, it's got to be even less than 6%, because that's assuming it was stormwater runoff, which doesn't occur. So the report findings, though, did say that many of the septic tanks on Captiva do not have adequate separation between the bottom of the drain field of the septic tank and the wet season water table compared to the regulatory criteria and non-regulatory guidance. I want to get into septic tanks. If you want me to describe how they work, I could. But basically, a septic tank has what's called a drain field. So there's treatment within the tank, and then it kind of, via gravity, flows out into this drain field, which is just a series of perforated pipes that basically trickle or discharge that water over an area, typically through clean sand. They sometimes bring in the sand. And that has to be aerobic. In other words, it has to have oxygen, not be underwater. Okay? That would be anaerobic. So it has to have that trickle-down concept to work. Okay? And what's happening is, if these tanks, if you put in the tank and it doesn't have that percolate down, or it's too close to the water table, it doesn't function properly. And so, in other words, it can release more nutrients. It doesn't have that attenuation effect. So if you go in Captiva, you will see, if you look very closely in some of the front yards or whatever, you'll see a mound in the front of the house. That's because they had to elevate the tank to meet code to get that. So you're kind of moving away from the water table. So the report did say increased sea level rise over the next 30 years is expected to further exacerbate this issue, okay? And that the decreased separation between the drain fields and the water table is likely to reduce the efficiency of soil-based wastewater treatment processes over the next 30 years, perhaps resulting in impacts to water quality that are not yet occurring on Captiva Island. So they really kind of zeroed in on, hey, this could be a problem in the future with the septic tanks that are on site. So in conclusion, rules and regulations of Lee County and the South Florida Water Management District require developers and water use permit holders to maximize conservation of groundwater through the use of alternative irrigation supplies, or AWS, alternative water supplies. Reclaimed water, in this instance, is only used on the golf course. Other areas of the resort are irrigated entirely by groundwater through their water use permit. Only the golf.
Say this again?
Only the golf course area gets reclaimed water.
Right, other areas.
There's other areas, they're groundwater. Yeah, it's only supplied that one area where those monitor wells are at. Reclaimed water is augmented with groundwater prior to being used for irrigation. On average, over the last, like I said, 18 months that I looked at, about 20%, sometimes more. DEP has required groundwater monitoring of the areas that are irrigated by reclaimed water, and that data does not, and I looked at almost 10 years of data. If you look at that plot that I had, I went all the way back to 2015, does not indicate elevated nitrogen levels above groundwater standards. So, and again, as stated earlier, FGUA is in the process of being awarded a grant for improvements to South Seas wastewater treatment plant. And although this is kind of cut off, a study for Captiva Community Panel Wastewater Committee indicated that efforts to reduce, so that same report that I referenced earlier, to reduce nitrogen loads from stormwater runoff, that's the most cost-effective mean to reduce nutrients in surrounding Captiva, stormwater runoff. And again, as I had just previously testified, this is a zero discharge stormwater facility, the golf course area. So with that, I'll take any questions you have.
Madam Hearing Examiner, do you have any questions?
No.
I have a couple questions. Mr. Grosso wrote a letter and testified for 3 hours in regard to the items in the letter. And in that letter, it says, until and unless the applicant can provide a capacity analysis report completed more recently than December of 2015, which verifies treatment capacity for the plant, the application must be denied. In your expert opinion, is it the applicant's job to provide an updated capacity analysis, or does the applicant have a right to rely on permits and DEP?
Absolutely, the applicant must rely on the permits issued by the Department of Environmental Protection and/or the Water Management District. Yes.
So it goes on to say, Captiva is a fragile coastal barrier island surrounded by the Gulf of Mexico and the Pine Island Sound. The FGUA plant is located within tidal mangrove wetlands and has a history of emergency sewage spills and treatment issues. Moreover, the FGUA plant does not treat wastewater to advanced wastewater treatment standards, and the reused water distributed as irrigation to the golf course will contribute to additional cumulative impacts to the water quality of Captiva's coastal water bodies that are already listed as impaired by the state of Florida and are on the state 303D list of impaired water bodies. According to Mr. Evans, the FGUA wastewater treatment plant is not currently capable of treating wastewater to a level that will protect Captiva's coastal waters and will further impair the coastal and estuarine waters and resources of Lee County and will contribute to the decline of Lee County's coastal ecosystem. I know that's a lot. I can hand it to you to reread. But do you have an expert opinion as to whether or not Mr. Evans is correct that we are going to destroy the coastal resources of Lee County by using the FGUA plant?
No, you're not going to destroy the natural resources in and around Captiva. Again, as I have testified, the reuse water itself, the reclaimed water, is monitored okay, monthly by DEP. The permit only lasts for 5 years. So you've got to prove yourself up every 5 years on this. In addition, I don't believe, just like ESA, that they understood that reclaimed water is diluted or buffered by groundwater. In addition, we have this kind of feedback loop that we're looking at the monitor wells in and around the area where reclaimed water is used. And no, we're almost at AWT standards at this point. We've never violated, or the 18, I'm sorry, I looked at about 10 years worth of data. We've never violated state water quality standards in those monitor wells. And in fact, they're well below and average less than 3 milligram per liter. So no, this is not a source, a significant source of pollution by any means.
Okay, well, this may be a dumb, blind question, but if we're talking about water quality standards, is it the state water quality standards that we all rely on?
Absolutely.
Okay, so no matter whether I'm in the county, the city, or wherever in the state of Florida, those are the applicable standards,
Absolutely.
and they've never been violated.
Not in the 10 years that I looked at.
Okay.
And they wouldn't recertify this plant if it was continually violating state water quality standards. They couldn't get a permit. You just couldn't do it.
I don't know if you know, but everything outside of South Seas is on septic tanks.
Yeah, in reading that report, they have some maps and some areas on septic tanks, yeah.
So is there an impact from other hotels and commercial and residential, potentially from their use of septic tanks on the coastal waters?
Certainly can be, for the reason that I testified to about that water table depth and those tanks not working efficiently, and that with sea level rise, that efficiency is going to go down over time. So absolutely. And that's why there's a big push in Florida to get people off of septic tanks and onto wastewater treatment plants.
Okay, you talked about a closed system, and usually when we're in this forum, when we look at surface water management systems, we have what I call the little blue arrows that show how the water goes through the site and shows where we discharge it off-site. So that seems like a normal system, is that right?
Right, typically.
But so in this case, there's no little blue arrow off-site. So the little blue arrow would either be up into the air or down into the ground.
Is
Correct.
golf course only or resort wide?
Only on the golf course where the reclaimed water is applied. Yeah.
So if it goes down, it's already the quality is being monitored by the system that the EP put in place.
Correct.
Okay, so the hearing examiner expressed a concern as to whether or not monitoring conditions are necessary to track the impact of reused water on the estuarine water quality. The same concern raised by Mr. Evans and Mr. Grosso.
Mm-hmm.
Do you have an expert opinion as to whether or not additional monitoring is required above and beyond what DEP has already required?
None whatsoever. I mean, the reuse water is being monitored at the plant. It's then being diluted, okay? Then it's being chlorinated, applied, and then it's being monitored again by the monitor wells.
And does surface water quality need to be monitored in light of the fact that there's no little blue arrow off-site?
Right, why would we? Yeah, no need to.
On the golf course?
Yeah. And again, because of this nutrient, this issue with reclaimed water and potential nutrients.
So, and then there's a question, clarify whether golf course water management system directs untreated runoff away from saltwater wetland systems.
Yeah, absolutely.
Up or down?
Yeah, it only can go towards the pond and evaporate or infiltrate at that location, or in the areas where it's irrigated.
Okay. Thank you. I don't have any other questions.
Thank you, this was helpful.
Madam Hearing Examiner Carl Bracco, again back for the record. I'm going to go over the drainage and water quality aspects of the water management system, but first I'm going to start with the lake slopes and littorals because we heard a little bit about that during public comment. And I'm going to first talk about the recent golf course renovation the Timbers undertook at the golf course. The original slope in the lakes was 4 foot horizontal, 1 foot vertical. That was the standard county criteria back when they were originally developed. All of the work recently done under the golf course renovation is based upon the current criteria with 6 foot horizontal to 1 foot vertical slopes and with the required littoral plantings. That is evidenced by, if I could find, yeah. This is the approved development order, and this is the approved water management permit for that work. And these are sections out of the approved plans. First, I want to show you the 6-to-1 slope, which is here, noting that the other side of the lake, which is at Land's End, was not touched because that's not under Timbers' control. They don't have a drainage easement, so the work started below the control elevation on the Land's End side. That's this section here. The next thing I'd point to, and it's small, but you'll see it when you look at the hard copy, is littoral plantings here. Looking at the plan view, this is the section 2 that I'm talking about here, and this is the lake that was reconstructed. This is the lake slope that was untouched. And you heard some testimony that the person was concerned that that lake slope was moved or addressed, and it wasn't touched as part of this project because they don't own that land. They don't have a drainage easement over that land. So a few things. During public testimony, we heard a gentleman talk about the lake slopes that were very steep and didn't have any littoral plantings. And Ms. Montgomery asked him how he came to that conclusion, and he said he used aerial photograph interpretation. I can only assume that he looked at those aerial photographs prior to this construction because this is so recent. But this is a photograph of the lake slopes the day that testimony was made. And you can see that the lake slopes are very gentle and littoral plants are very healthy. And again, this is the certificate of compliance issued by Lee County when that work was completed. That certificate of compliance is dated February of 2024. There was also some concern about lake slope deviations, and that lake slope deviation was simply requested to memorialize the older slopes that have not been upgraded. So that there are some slopes that are a 4-to-1 slope as they were originally designed and permitted, and they were not part of the recent renovation. Having said that, any future lake slope work would be consistent with current criteria, which is the 6-to-1 slope and littorals. Now I'm going to go into the history of the surface water management system. The water management permit was originally issued in 1985, and I mentioned this in the original testimony. This was a surface water management permit. That's how old it was. It's not an environmental resource permit as we would currently see and currently talk about. So that permit was issued, and the next thing I want to do is reference the Brazaga report, which you've heard about, and point particularly this language here, where Brazaga concluded reducing runoff is an important strategy for improving water quality. And that's really, really important to this entire system because this entire system from day one is a full retention system, and that's shown in this slide here. This is a copy of that water management permit. Its stormwater system is full retention, and you heard Mr. Brown say there is no positive outfall, and it's total on-site retention.
We're talking about the golf course, right?
No, I'm talking about the entire water management system. And I believe Mr. Brown was talking about the golf course because he was talking specifically about the golf course irrigation. But
So the entire MPD, the stormwater system is full retention.
Yes.
So the water's either evaporating up or going down into the groundwater.
And I have another slide that I'll go over with you, a little bit more detail on that. And here we go. If it would help, I have hard copies. Would you like a hard copy?
Oh, I could see.
Okay. So this first is a typical detention system, and you've heard about those in every hearing you've been to. And the key is that D, it's detained. The water is coming off of the developed area into the detention system. It's detained, held back, but it's allowed to leave slowly through this control structure into the receiving waters to emulate the historic conditions. So this is a detention system. The water comes into the detention lake, but it's also leaving. And the important part about that is when we talk about monitoring schemes in the past, we have a place to do the sampling. We have, at the outfall of the system, an opportunity to collect that water leaving the system and analyze it. Now you're going to see the little arrows that you heard about. These aren't blue, but they're up and down. I'm going to start right here with the retention system, and this was an R. As you heard, these arrows, that's evapotranspiration. The water is either evaporating or going through the plant material and into the atmosphere. And we also have infiltration into the groundwater here. Well, how does that water get in? Right now, today, in this developable area, which you heard Ms. Olson talk about, that water is already treated in the existing condition, in the existing permit. All the water in the system is treated. We're going to go above and beyond that and forget that, and we're going to look at new projects, and this is a good example of the beach house. So the area the beach house was on was already in the water management permit, already in the drainage area, and it was already going to these retention areas. But we're not going to consider that. We looked at the existing design requirements for pre-treatment and added an exfiltration trench here. So the water from the developed site comes into the exfiltration trench, has an opportunity to go down into the soil, and there's a control structure here that holds that water back and allows it to go into the infiltration. When we have a heavy event, it does overflow that and it comes into the retention area. But again, at that point, it's retained and it's not leaving the site. So that's the new design. Taking that a step further, and at the beach house, I'm going to use round numbers. These aren't the exact numbers, but it'll give you an idea of the magnitude. If we calculated that we needed 100 feet of exfiltration trench to provide the pre-treatment needed, we went in excess of that, and in this case, I think it was around 50% extra. So we're going, whenever we can, and we have the area, we go above and beyond. So there's really 3 levels of pre-treatment. The original pre-treatment that was in the original system, the introduction of this exfiltration trench, and going above and beyond that required in designing that exfiltration trench.
What exactly is an exfiltration trench?
So it's a perforated pipe, and the water is collected in a series of pipes or swales directed into this this pipe, and this pipe is wrapped with 57 stone, and then around the 57 stone is filter fabric, so that, if I'd known you were going to ask a question, I would put a section up there. So you have basically a rectangle of rock with a pipe in the middle, and all the drainage goes into that pipe, goes through the rock and into the soil. When there's a heavy rainfall and it can't release quick enough, it will overflow into the retention area. Those are the new systems that we're adding.
Thank you.
So this is both the systems I just talked about, and the point I'd like to make is that, again, this detention system has this outfall point and a sampling point. This only leaves the retention area when it is above the 25-year stage, so that doesn't happen very frequently at all. It's really not significant in terms of water quality. Given that, there is no way to collect a sample because all the treatment's happening here, so there's no point in taking a sample where the treatment's happening. We would expect that to show some level of contaminant. In the state of Florida, we can obtain a water quality certification from the South Florida Water Management District, but only when the proper design is approved. This is a copy of a permit from the South Florida Water Management District for a project that we just did in South Seas. It's dated March 2024. And as part of that permit, and this one's cut off too with the image on the screen, but I'll read it to you. Issuance of this permit constitutes certification of compliance with state water quality standards in accordance with Rule 63, so on, so forth. So we're obtaining water quality samples from the state of Florida on all the projects they're working on now, and we'll continue to do that as we go forward. The next is the water quality criteria, and this is important because it's changed so much since we started designing modern water management systems, which is roughly in the 70s. Initially, back then, there was presumptive criteria that were put together, and basically at that time, it was an analysis where you would look at how much impervious area you have and the rainfall, and based upon some equations, determine what volume of runoff would have to be treated prior to discharging. And so if you provided that volume of pretreatment, you were presumed to meet water quality standards. Since then, and this is the last few decades, there's been a lot of study done, particularly in Florida, and particularly at the University of Central Florida. And they evaluated stormwater characteristics from many different land uses, developed and undeveloped, and took samples and analyzed the water quality. So now we know the characteristics of water leaving the sites. They also looked at evaluating treatment efficiencies in the systems that were using to treat the water. And based upon those two things, the state of Florida developed a quantitative analysis, so now we can look at a system and we can determine exactly how much of the constituents are being removed in any particular design. So in conclusion, in my professional opinion, the systems added by South Seas Island Resort to date and systems added in the future resulting from this application will improve water quality of the surrounding tidal waters and will serve as an example of what can be done cumulatively to improve local water quality in a significant way. And in building on some things that Mr. Brown said, another way to say that is South Seas Island Resort water quality improvements are a start. But real cumulative impacts will not be realized until runoff from older properties are treated, and as South Seas is doing now, and on-site septic tank systems are addressed in one way or the other given sea level rise. That's what I have on water quality. If you have any questions, I'd be happy to try to answer them.
Thank you. Neil, do you have questions of your witness?
I do. Mr. Baraka, do you have an opinion as to whether or not an exfiltration system is better or the same as lake retention?
In this particular instance, with the soils we have, I think an exfiltration trench is well suited, much better suited than many other parts of South Florida.
Okay. And there's the hearing examiner has a question about whether or not, well, let me go back. Asked a question about golf course water quality conditions, and one of the projects mentioned is Pelican Landing RPT CPT. That was approved in 1994, and I won't say why I know that. At or about the time, there had been a fish kill in a golf course in Doral where the water was bright blue. If you know, do you know whether or not the constituents that can be used in golf course fertilization have changed over time?
I don't know.
And if you know, have you worked on any projects where there's golf courses where it is the water quality has been monitored?
Yes.
Have any of them had exceedances?
Not that I'm aware of.
And I'm going to sort of testify. The Pelican Landing RPT CPT did water quality monitoring for 20 years, had no exceedances, but it did cost $20,000 a year. So we went back and amended it to remove and adjust that condition because of the fact that the system worked. And I guess that's my question to you. If the system works, will there be a water quality issue?
No, and another good example was a project I worked on, Paseo in the city of Fort Myers. That had a monitoring program. It was for a certain amount of years that would cease after consecutive results, acceptable results were provided, and that happened rather quickly. I don't recall any year where there was an issue with that. So
Okay.
another good example of how the systems work.
And then number 19, it says surface water and groundwater monitoring conditions are necessary, and there's some explanation, but then it ends with, this requirement has been imposed on other planned developments in the county, including those with outfalls to natural water bodies. Based on your explanation, is there a distinction between projects that outfall to natural water bodies and those that don't?
Yes, and the clear distinction is there's no place to obtain a sample to analyze in this retention system.
Right, because we're not discharging. Okay, so question 21 was describe the planned enhancements to the surface water management system. In your opinion, what are the enhancements that have been put in place as have you modified the system?
As I went over with the beach house, not even considering the original water quality that was in the system for that land mass, we did an exfiltration trench and went above and beyond that was required to satisfy current standards.
And I think you've answered this, but just to be sure, clarify whether golf course water management system directs untreated runoff away from saltwater wetland systems.
Yeah, I can say that all of the turf area in the golf course is directed to the retention system.
So we're not discharging anything to saltwater.
No, all of the turfed area is directed to the lakes.
And I think your slides earlier addressed this, but we just want to make clear, will on-site lakes include littoral shelf consistent with the code?
The current,
In the future?
The current lakes do, yes.
Okay. All right. This probably isn't a you question. Given the location on a barrier island, is it appropriate to specify types of littoral plantings?
Yeah, that's not me.
I knew that, but I thought I'd give it a shot. Thank you. I don't have any other questions.
You can sit. Can we do one more witness before lunch? Okay. Court reporter saying one more witness before a lunch break. Do we have someone?
Yep, yep, yep.
Glad to be your last witness before lunch. Thank you. And Madam Hearing Examiner, just in case it wasn't in file, I was going to give you a copy of the resume. You should have it. But
Thank you.
again, to sort of add on to comments from Mr. Baracco and prior witnesses, wanted to focus in on the Captiva Island Vulnerability Assessment and Adaptation Plan done by Brazago, which is a well-known resilience firm here in Florida, and paid for by the ownership group. I believe it's been referenced by prior testimony, and wanted to submit the entirety of it so you could have not just quotes, but the full.
Okay, thank you.
And I would just sort of take a step back and make the high-level comment that during my prior service, had the privilege of creating the Office of Resilience and Coastal Protection at the Department of Environmental Protection. Sorry.
Slow down. Of creating the.
During my prior government service, I had the privilege of creating the Office of Resilience and Coastal Protection at the Department of Environmental Protection. And one of the goals of the state was to have local governments and others fund and implement vulnerability assessments and adaptation plans. And the point of that was to be able to have a prospective look, identify risks, and then be able to mitigate those risks or reduce the impacts of those risks, right? And to the point that the state actually created a grant program to provide funds to local governments so that they could hire firms such as Brazaga to do vulnerability assessments. And the idea was to put all the state in a better spot, not to retreat from coastal development, but to inform how we develop. I will say this is the only instance I'm aware of where you have a developer that I've worked with that has actually chosen to fund a vulnerability assessment, not just for their own property, but the entirety of this island. And that's important because at that point, back in 2022, when this was commissioned,
Right before the hurricane.
right before the hurricane, but also as the state was embarking on this big initiative to encourage local governments to do these vulnerability assessments, one of the ways they encouraged local governments to do vulnerability assessments, money always helps, was in section 390.083, it said you have to have, right, one of the ways to be eligible for grant funding is to have a statutory compliant vulnerability assessment. It was sort of the first do a vulnerability assessment or show us that you've started work and are paying for a compliant vulnerability assessment. And then you can come over and get access to this other bucket of grant funds to actually implement projects. And so that was meant as a way to encourage everyone to do this. I think the development group needs great credit for they saw that there was not a compliant vulnerability assessment that we were aware of for Captiva Island, and so therefore it was a barrier should anyone on Captiva Island, for Lee County, want to go and apply for the state at that point for resilience grants, that would have been a barrier to doing so. And so this actually helped then allow Captiva Island to, should they choose, apply for those vulnerability grants. That's one of the reasons that vulnerability assessment was done. As you'll read it, the point is to identify risks. Obviously, in this instance, flooding, sea level, or storm surge being the main risk, and the main way to de-risk that and not have an impact, again, is the point of this vulnerability assessment, is elevation. I know you've heard at length the efforts the development is going to elevate structures to meet modern day permit and go even beyond that. I'll mention Lee County and Sanibel currently now both have active grants where they're getting funding from DEP to do just this, to do comprehensive vulnerability assessments. And sorry to go on my tirade here, but you see results from that, right? The green dots are funded infrastructure projects, the yellow dots are planning projects. You see more funds going for actual infrastructure projects where there are more vulnerability assessments because local governments and others are then able to understand where they should be investing. Should we be investing in elevation of structures or storm hardening, things like that? And so vulnerability assessments have a direct consequence of having better development, which is what you see here. I would say it's almost a master class of how to do resilient development here in Florida. And so I'll just touch on a few of the things that I think are unique and really impactful and I know you've already heard many of these, but increasing the coastal dune system, right? Having natural features help with resilience. And so in this area, there's actually been a reduction of portions of the footprint of the golf course to put back in dune structures along the coastline, in addition to the dune structures being built on the beach by the Captiva Erosion Control District. That smaller golf course design also includes greater water retention, right? That, to me, is a novel thing that have seen elsewhere in Florida, where you begin to think about a golf course to say, hey, can this serve as even better stormwater management too, not just the golf course? In addition to that, as I mentioned, elevation is key, right? Having modern structures to elevate above storm surge so that while that vulnerability assessment identified that risk, when you've developed correctly, you've eliminated that risk for your development. Other things that you've seen after hurricanes, right, is lack of power and the impact that can have on your development, either through mold, no AC, electric, and I'll highlight a couple here, is that you've seen designs for buildings with roofs that allow for installation of solar and buried electric, two really key items for vulnerability here in Florida. And then lastly, I'll say we were privileged to be engaged by them to work on environmental programming. It is rare that I've seen any development in Florida go to the length of actually funding a vulnerability assessment beyond their boundary so that an entire community can apply for grant funds, as well as do as many of these. Usually you see one or two that someone picks, not go through the whole list. And with that, I believe I won't stand between you and lunch, unless you have questions.
I do. Are you aware of the fact that after the hurricane, Lee County adopted an ordinance providing for consistency in how height's measured, but which allowed for additional resiliency?
I am.
Do you have an opinion on whether that was, from a resiliency standpoint, a wise thing to do, especially in light of sea level rise and climate change and the things that you've discussed?
Absolutely. I mean, my professional opinion, probably the single most consequential thing Florida can do, local governments can do, is to make sure that folks are able to elevate their structures, right? That the rules are clear and simple for that, and that the permitting is quick, right? The thing that you want to see now and after any hurricane is the ability to quickly invest to improve our coastal infrastructure. We have a lot of old development along Florida's coastline. What we need is a quick, clear pathway, and one of the key things is rules for how to elevate your structures and to make sure that you have a clear path to elevating your structure. You're not making a choice between losing square footage on what you had, right, and elevating, but that you can simply elevate your structure and move forward.
And so the ordinance allowed everyone else who just relies on the land development code to rebuild essentially what they had, starting at a higher elevation that's safer.
Correct.
The ADD in this case didn't allow that to happen because we're still tied to measuring from sea level, not at the FEMA elevation or 1 foot above base flood elevation.
It was a perfect example of complicated regulation that ended up forcing a property owner to try to decide between reducing their development footprint, you know, the size of their house and structure, or elevating, right? That you could either elevate and then have that impact what you could build. It was one or other. And I would mention not clear.
And during the adoption of that, Michael Jacob, Assistant County Attorney, referred to that as the squeeze, that they were trying to avoid the squeeze.
I think that's a good phrase for it.
So in other words, if I have a 3 or 4 story building now and it gets destroyed, I would be squeezed and not be able to rebuild it. Is that your understanding?
That is correct.
And that's part of what resiliency was trying to avoid, that kind of negative impact.
Again, I think the most consequential thing Florida can do, again, local governments, others, is to make sure that there's not an argument over starting point, that you know that you can start above the point where you have a risk of storm surge or flooding, and that the rules for that are clear. And that is my understanding is actually what the county was taking on and what was the problem on the island before.
Okay, thank you.
Thank you.
Thank you.
All right, we're going to take a break for lunch.
Okay.
Why don't we try to be back here by 1:30,
Okay.
and we'll proceed.
That's good.